That's where we're at. That's good. Yeah. Hey, of course, ready whenever you are. Okay. I see. Okay, and then that 2434 is here too. Yep, no problem.
All rise.
All right, thank you. Please be seated.
gotta log in again. Hold on. All right, can the interpreter hear me?
Yes, Your Honor.
Okay, thank you so much. All right, this is the 11 a.m. initial appearance calendar for April 25th, 2025.
Este es el calendario de comparecencia inicial del día 25 de abril de las 11 de la mañana.
The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the 1st of this month will also apply to these hearings.
Las órdenes del tribunal de que la oficina del comisario les tome sus huellas dactilares y muestras de ADN que fueron realizadas en el calendario de las 2 de la mañana, el primer día del mes, se aplicarán a todas las causas de este calendario.
And we are going to start with Mr. Trejo. Will you please come to the podium?
Señor Trejo, vamos a empezar con usted. Por favor, pase al podio.
And after that, Carlos Lopez, will you wait in the chair? You'll be after him.
Y después, Carlos López. Por favor, si gusta esperar en la silla, usted sigue después de él.
There's a chair just inside the door, Mr. Lopez. Just wait there, please.
Hay una silla que está del otro lado de la puerta. Por favor, siéntese ahí y espere.
All right. Sir, may I have your full name and date of birth, please?
Señor, ¿me puede dar su nombre completo y fecha de nacimiento, por favor?
Carlos Trejo Díaz, noviembre 4, 1990.
Carlos Trejo Díaz, November 4, 1990.
And was the state wanting to be heard in this case?
No, thank you, Your Honor.
¿Y el Estado quiere ser escuchado en este caso? No, gracias, señoría.
All right. Mr. Trejo, you have been arrested on the following allegations.
Ok, el señor Trejo ha sido arrestado por los siguientes alegatos.
Possession of dangerous drugs for sale, a Class 2 felony.
Tenencia de estupefacientes para venta, que es un delito clase 2.
There is probable cause for that offense, and I am appointing a lawyer to represent you.
Existe motivo fundado de procesamiento de esa acusación. Le voy a asignar un abogado para que lo represente.
Your next court date will be a status conference on Thursday, May 1st at 8:30 in the morning in the downtown Superior Court.
Usted va a tener una consulta de actualizaciones. Su próxima audiencia va a ser el día 1 de mayo del 2025. Eso es un día jueves en las instalaciones del centro del Tribunal Superior.
Your preliminary hearing is scheduled for the following Monday, May 5th at 8:30 in the morning.
Y su audiencia preliminar va a ser el siguiente lunes, el día 5 de mayo a las 8:30 de la mañana.
The court address is on your paperwork.
Las direcciones del tribunal van a estar en los documentos que le vamos a dar.
Based on the large amount of drugs that have been alleged against you,
En base a la gran cantidad de drogas que se argumentan o se alegan le encontraron,
your prior conviction for this exact offense,
y su condena anterior por un ilícito exactamente igual a este,
and your prior felony conviction for illegal re-entry,
y su condena por haber entrado o reingresado de forma ilegal al país,
the court believes that you pose an extreme danger to the community and an extreme risk of flight to avoid prosecution.
se está determinando que usted es una persona que tiene un alto riesgo de poder huir de la justicia y también una persona que es un alto riesgo para la comunidad.
For these reasons, bond is set in your case in the amount of $250,000, and that is cash only.
Es por eso que la fianza en su caso es una fianza de $250,000 solamente en efectivo.
You have other conditions of release that will be on your paperwork.
Tiene otros términos y condiciones de libertad que van a estar en los documentos que va a recibir.
Those include that you may not leave the state of Arizona without the court's permission.
Eso incluye que no puede salir del estado de Arizona sin el permiso del juez.
And you must attend every court hearing.
For the interpreter, could you repeat, Your Honor?
Sure, and you must attend every court hearing.
Y debe de comparecer a todas las audiencias que se le impongan.
If you miss a court date, you will lose that bond money and there will be a warrant issued for your arrest.
Si usted no comparece a alguna de esas audiencias, perdería el dinero de la fianza y se liberaría una orden para su arresto.
Everything you need to know will be on your paperwork, and the officer will give you your copy right now. You can step out to your left after that. Thank you.
Toda la información está por escrito en el documento que le va a dar el agente y si gusta puede pasar al lado izquierdo.
Mr. Lopez?
Señor López.
Hello, sir. May I have your full name and your date of birth, please?
Buenos días, señor. ¿Me puede dar su nombre completo y fecha de nacimiento, por favor?
Carlos César Linares López.
Carlos César Linares López.
And your date of birth?
¿Y su fecha de nacimiento?
El 27 de febrero de 2002.
February 27, 2002.
Thank you. You have been arrested on criminal charges that actually date back to 2022.
Usted fue arrestado por acusaciones de tipo penal que tenía en su contra desde el 2022.
You have now been formally charged with one count of possessing narcotic drugs, which is a Class 4 felony.
En este momento se le está haciendo la acusación formal de tenencia de narcóticos, que es un delito clase 4.
And possession of drug paraphernalia, which is a Class 6 felony.
Y tenencia de vehículos para consumo de drogas, que es un delito clase 6.
The alleged offense date is October 18th of 2022.
La supuesta fecha en la que ocurrieron estos ilícitos es el 18 de octubre de 2022.
You will receive a copy of the charges and police reports through your lawyer, and I am appointing a lawyer to represent you.
Usted va a recibir copia del informe de policía y las acusaciones en su contra a través de su abogado. Le estoy asignando un abogado para que lo represente y él le va a dar estos documentos.
Your next two court dates will be a status conference on May 1st at 8:30 in the morning.
Sus próximas audiencias son una consulta de actualización el día 1 de mayo a las 8:30 de la mañana.
And a preliminary hearing on May 5th at 8:30 in the morning.
Y una audiencia preliminar el día 5 de mayo a las 8:30 de la mañana.
Court address is on your paperwork.
La dirección del tribunal está en los documentos que le van a dar.
This is a newly filed case, and you have not missed any court dates in this case.
Este es un nuevo caso que acaba de ser presentado y usted no ha fallado a presentarse a las demás audiencias que ha tenido programadas.
So I'm going to release you on your own recognizance to get yourself to court on those dates.
Así es que lo voy a dejar en libertad bajo palabra juramentada y usted tiene que llegar a esas próximas audiencias.
If you miss any court date in this case, there will be a warrant issued for your arrest.
Pero si no se presenta a alguna de las audiencias que tienen programadas, se va a liberar una orden para su arresto.
Everything you need to know is on your paperwork. If you please step to your left, the officer will give you your copy. Thank you.
Toda la información que requiere está en la documentación que le va a dar el agente. Por favor, pase a su izquierda.
All right, if the interpreter could make a general call, please.
Yes, Your Honor. ¿Habrá alguna otra persona que requiera los servicios de intérprete en español?
Do you see any hands, officer? Okay, we're good to go. Thank you so much to the interpreter. Have a great day.
You too. Thank you, Your Honor.
Thank you. All right, and I think I can probably take your matter out of order, counsel. Are you here for Daniel Darrow?
Yes, Your Honor.
Okay, let's go ahead with that. Mr. Darrow, please come to the podium. After that, it's going to be Vincent Lechuga. I can't promise that I always will, but when I can, I do.
Absolutely, I appreciate it.
All righty. Mr. Darrow, let me have your full name and your date of birth, please.
Daniel Darrow, 2/25/98.
Okay, thank you. And then the appearance of counsel, please.
Thank you, Your Honor. Stephen Garcia, on behalf of the state, good morning.
Good morning. And defense.
Good morning, Your Honor. Jacob Wilson on behalf of Daniel Darrow, who is present in custody, standing at the podium.
All right, thank you very much. All right, Mr. Darrow, you're here on a probation warrant and a new case. I'm going to start with your new case. You were booked in on one allegation of theft by control of a stolen credit card as a Class 5 felony and theft of property in the amount of $1,000 or more, and that's a Class 6 felony. Before I make a ruling on probable cause, Counsel Wilson, I am inclined to find probable cause based on what the police submitted. Did you want to be heard on that before I do?
No, Your Honor.
All right, thank you. Mr. Darrow, based on what the police submitted, there is baseline probable cause for these offenses, so I do find probable cause for both of them. And your lawyer can explain to you more about how that works. It's not a high standard, and the police have met it today. Alrighty, so, counsel, I didn't have a chance to look at your NOA. Are you in for the whole case or just the appearance?
We are entering the whole case. Well, actually, I take that back. At the time being, we're entering the appearance to be completely...
Just for today?
Yes.
Okay.
To be completely fair, I was at Maricopa County Superior Court and was just told to come. So I'm still in the review process of exactly where we're at in the hiring process.
All right, so it sounds like I should go ahead and appoint the public defender as a backup?
I would go ahead and appoint the public defender as a backup. It sounds like we need to speak to the person who's funding this case as soon as the initial appearance is done. If so, we will file a substitution before that hearing. All
right, so what's going to happen, Mr. Darrow, is you always have the right to hire the lawyer of your choosing, or if somebody does that for you, that's fine. I'm just going to appoint the public defender, so if that doesn't happen right away, or if you don't ever arrange to do that, you will have a lawyer for you. And if you do hire a lawyer, the public defender will happily withdraw. So I am appointing the public defender for you in this new case. I'll also go ahead and appoint them in your probation case, again, as a backup. And in this case, this is a term 1 hold, which means the probation department will be filing a petition to revoke your probation based on this new arrest. So you need a lawyer there as well. And I will give you your court dates in a moment. Before I do that, I want to hear the state's recommendation, if any, on release conditions.
Thank you, Your Honor. Your Honor, the probation case notwithstanding, we'd leave that to the discretion of the court when that time comes. But Your Honor, we are asking for a $5,000 secured appearance bond in the underlying matter. It does appear he has several prior felony convictions. 2 possession of narcotic drugs from 2018, older trafficking stolen property conviction, as well as a theft, both class 3 felonies. And obviously he is on probation for the underlying 2022 possession case. So with that background and that context, Your Honor, here it appears he took somebody's bag from a Mountainside Fitness Center, was seen on video surveillance leaving that center with the bag, and then was later seen on video surveillance at a local gas station where it reportedly a credit card was used with the same victim that where the credit card had come from in that bag earlier that day from the Mountainside Fitness Center. So video surveillance did show the defendant making the transaction at the gas station. So obviously he's committing a similar nature of offense as a couple older prior felony convictions of his. Thank you.
Okay, thank you. And Mr. Wilson.
Your Honor, I only located 1 felony prior in this case, and I have public access to that's the extent to what I've...
Let me tell you what I'm looking at, and then you'll know. Okay, what I have from pretrial is 2020, narcotic drugs, 2.5 years in DOC, 2017, narcotic drugs out of Phoenix, probation. And if you want that case number, counsel, it's CR 2017. 114102. Did you need the other one, the one he went to prison on, or is that the one you saw?
Is that the one with the probation tail that he is here for the petition to revoke?
It's hard for me to tell from these dates, but it's CR 2021 030410.
Could you say the last 6?
Sure, 030410. Okay. Then in 2016, felony theft, probation with 4 months jail, and that was CR 2016-152642. And that is one where he took two felonies in the same case. There was a trafficking and stolen property in the 2nd degree and a theft in that same 2016 case. So that was 2 convictions in that case. And finally, in 2016, he took a conviction for narcotic drug possession, and that is CR 2017-002-811. So I'm looking at a total of 5 priors over 4 cases.
Okay.
Okay, go ahead, counsel.
Thank you for the background.
Sure.
That obviously changes my recommendation quite a bit, and I think that the state's recommendation in this case is likely appropriate. The only thing that I would ask is for the probation matter for him to, it sounds like he's leaving it in the discretion of the court to make him bondable or non-bondable. We would ask that you make him bondable in that case as well.
He is by law. I showed that is a misdemeanor probation case, so I believe he's categorically entitled to bail.
And background on the case, as far as that misdemeanor case, he has looks like he has like a 2016 DUI, but it shows as dismissed. So the ignition interlock requirement, I don't understand why it was imposed. I'll have to do some more background research into that case. So it's not something, and I spoke to my client before we came in here today, that he was willfully warranting on. It was likely something that was a mistake, or it is either something that is missed and not mailed to the correct address as far as having the ignition interlock requirement. So I have very little concern about him having a failure to appear. Recently, I've spoken to his mom, and he's hired private counsel in this case. He has a very good family that will transport him to all hearings. I have also advised him of the consequences of doing so. He knows that the petition to revoke is also very serious and he could be sent back to prison. So I have no concern that that is going to be an issue. So for those reasons, we would ask for $5,000 secured in all cases, and so that we can just get him out and get him on the right steps.
Okay, thank you. Give me 1 second. All right. Mr. Darrow. You need a second, counsel? Go ahead, push the button on the microphone, though, counsel, because we live stream. You don't want to accidentally get picked up. Okay. All right, Mr. Darrow, I've considered what's been alleged against you in this case, which appears to be a strong weight of the evidence, and your 5 prior felony convictions. I've considered the fact that you're on supervised probation for a misdemeanor theft offense. I've considered the victim impact statement, which it sounds like there was a serious effect on this alleged victim, and the likelihood that you're going to continue to commit theft offenses to support a drug habit. So I agree that the state's recommendation is appropriate. It's $5,000 secured. But this court believes that you're highly likely to continue to try to steal to support your drug habit. I assume you're likely to be able to post that bond. So I'm going to put you on house arrest. You could be out of custody and you're going to sit at home. And that is also because I think there's a reasonable likelihood you're going to be convicted. You've been to DOC. You've got 4 priors, 5, depending on how you count them. So the state has a considerable amount of leverage against you. The court is also very concerned that you're not going to voluntarily appear for court once you figure out what their offer is likely to be. That is certainly up to the state. But in this case, you face conviction with 2 priors. So I think these days, in my day, we called that something different, but it's a category 3 or something. So I think we call it now. So, and again, it is only a class 5 felony, and I don't remember the presumptive for a category 3 with a class 5, but it's years. So, obviously, you can't go to the scene of the alleged crimes. You can go where pretrial lets you. House arrest means you have to ask. So if you have doctor's appointments, court hearings, whatever it is you're wanting to do, you must request permission. You'll be on an ankle monitor to prove where you are. No weapons, no drugs, no alcohol. You have to call your PO within 72 hours of release. In your misdemeanor case, I'm setting a $1,000 secured appearance bond. So that's $6,000 total. I'm only doing the ankle monitor in the felony case. If for any reason the felony case went away, you're just on misdemeanor probation. You could face 6 months in jail on that case, but not prison. So, Mr. Darrow, I cannot overemphasize, and frankly, if I was a betting person, I bet you can't do it. You cut that ankle monitor off, you could be charged with a class 4 felony just for cutting it off, and we would hold you no bond on that. If they charge you with it, you get held no bond on that because you'd be out on release for 1 felony, and then you get charged with a new felony for cutting your ankle monitor off. You're going to be held non-bondable, and the odds of you ending up in prison over this start to get rather overwhelming. So, Mr. Darrow, I hope that you're successful, but don't think that if you cut the ankle monitor off because you're tired on being house arrest, that it's ever going to end well. Absolutely no contact with the alleged victim. No weapons, no drugs, no alcohol. So it was $1,000 in the probation case, counsel.
Okay,
so $6,000 total. The ankle monitor and house arrest is only in the felony case.
Thank you.
All right, anything else from counsel?
Thank you, Your Honor.
Nothing.
All right, then we're done with that one. If you want to use the room, counsel, you're welcome to. You can just take the paperwork back there. I'm going to be in here a while. All right, Mr. Lechuga, Vincent Lechuga.
Yeah, no, I think so.
Then Nicholas Garcia, will you go to the chair? You can go right up to the podium there, just sort of squeeze in. All right, sir, can I have your full name and your date of birth, please?
Vincent Michael Lechuga, 9/13/91.
Thank you. You're here on a warrant from the Pinal County Superior Court. You're on probation there, and there was a petition to revoke your probation filed. So I'm going to let them know they should appoint a lawyer for you when you get there. And your court date there is scheduled for April 30th at 8:30 in the morning. They have ordered that you are to be held without bond, and I'm going to affirm that order. pursuant to the law quoted in my order. I think you have a pending case in Maricopa, so just FYI, I don't think Maricopa is going to let Pinal have you as long as you have a case going on here, but I still have to use that April 30th court date. I really doubt you'll go back and forth on April 30th, but if for any reason your Maricopa case was over, then Pinal would be told to come and get you, okay? But you are non-bondable in the Pinal case.
Okay.
All right, if you'll step to your left, they're going to give you paperwork. Thank you. Nicholas Garcia, and then Pepper Martinez. You please go to the chair. Are you going to sneak out, counsel?
Yes, Your Honor.
Okay.
Thank you.
Yeah, no problem. All right, Mr. Garcia, can I have your full name and date of birth?
Nicholas Garcia, 7/16/86.
Okay, thanks. You are here on one new case and a warrant in a pending case. In the new case, you were arrested for theft of a means of transportation and theft by control of property over $4,000 worth, and those are both Class 3 felonies. Possession of narcotic drugs, a Class 4 felony. Unlawful flight from a law enforcement vehicle, a Class 5 felony. Possession of burglary tools and drug paraphernalia, those are both Class 6 felonies. Theft under $1,000, that's a Class 1 misdemeanor. Failing to stay at the scene of an accident, driving on a suspended license, and criminal damage, those are all misdemeanors as well. There is probable cause for all of those, and I am appointing a lawyer for you. It will be the same lawyer in this case that you have for your other open case, which is number 46 on the calendar. You've been charged with theft by control of a stolen credit card. That's a Class 5 felony.
Yeah.
You failed to appear at a pretrial conference on March 13th, and there was a warrant issued for your arrest. You already have a lawyer in that case, so you're going to end up with the same lawyer for both.
All right.
I'm going to schedule a few court dates for you. The first one is going to be a status conference in the new case, the one from yesterday, and that will be this Thursday, May 1st at 8:30 in the morning, with a preliminary hearing May 5th at 8:30. And on May 5th, I'm also going to just set a status conference in the older case. So I'll put those together for May 5th, 8:30 in the morning. That's going to be on your paperwork.
All right.
Now, in the new case, because there is probable cause for a new felony, well, several, while you have this open and pending felony case, you must be held for a bail hearing. I cannot give you bail today. I have to hold you no bond and set your bail hearing, which that'll be 7 days from today, which is May 2nd, 1:30 in the afternoon. On your paperwork, it's the evidentiary hearing. You may or may not be found eligible for bail in the new case next week, but you are not eligible today. You're held no bond. Now, in the older case, the warrant case, you have a $2,500 secured appearance bond in written condition, but you shouldn't try to post that bond if you're still being held without bond in the new case.
Yeah.
You have the same lawyer for everything, and you should be seeing that person on Thursday.
Okay.
All right, everything's on your paperwork. If you step to your left, she'll give that to you. Thank you. Ms. Martinez, and then Kiet Lea, will you please go to the chair? First, I need Pepper. She's dressed out, officer. She looks like maybe like a little thing. Pepper Martinez, 5'5". Okay, thank you, sir. Pepper Martinez. All right, here we go. Hi, ma'am. Right there at the podium, please. All right. Let me have your full name and date of birth, please.
Pepper Michelle Martinez,
What's your date of birth?
3/11/72.
All right, thank you. You're here on three things. One is a new case, and two are probation holds. In your new case, you were arrested for shoplifting with 2 or more prior shoplifting convictions, and that is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. I'm also appointing a lawyer in both of your probation cases. You're on probation for a Class 4 and a Class 5 felony, and the probation department will be filing petitions to revoke your probation based on this new arrest. So you'll have a lawyer for everything, should be the same person for everything. And I'm going to give you, let's see if I can give you the same next court dates. Yes, I can. So in all three cases, your next court date is this Thursday, May 1st at 8:30 in the morning. And in the new case only, you're also going to have a preliminary hearing on Monday, May 5th at 8:30 in the morning.
Okay, is the shoplifting misdemeanor or felony?
Felony. Felony, ma'am. With 2 or more prior convictions in the last 5 years, it's a Class 4 felony. So your lawyer will go over that with you. In each of your 2 probation cases, the court finds that in all reasonable probability, you are going to be revoked to prison. So you do not have bail today in either of your probation cases. In the new case, you have a $2,000 secured appearance bond with written conditions, but you shouldn't try to post that bond if you are still in jail, no bond on your probation cases. You'll see your lawyer for everything this coming Thursday, and everything's on your paperwork. Please step to your left. Thank you. Mr. Lay, and then Sadie Reyes. Will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Good morning, Keith Lee, November 9th, 1999.
All right, thank you. Mr. Lee, you're here on a new case. You were arrested for theft by control of stolen property and worth over $1,000, and that is a Class 6 felony. There is probable cause for it, and I am appointing a lawyer for you. It'll be the same lawyer that you have for your other open case, which is that, actually you have more than one. You've got a shoplifting and trafficking in stolen property case, unlawful use of means, and burglary. Okay, so I'm showing you got 3 open cases.
Yeah, good.
No, that's not, you don't have to explain why.
Okay.
I hadn't realized. I thought it was 1. Okay. So in this case, there is probable cause for it, and so you're going to end up with the same lawyer for everything. Is it a PD? With that many cases, I wouldn't be surprised. Number 36, is he PD? I just thought it. We'll double check. Okay, thank you. All righty. So we're appointing a lawyer for you. It's going to end up being the same person. I'm setting 3 court dates for you. The first one is a status conference this Thursday, May 1st at 8:30 in the morning. Your preliminary hearing will be the following Monday, May 5th at 8:30. And you may have been through this before with this many cases, but I have to hold you no bond today because you're accused of a felony while you have an open and pending felony case, and you have 3. So your bail hearing is going to be 1 week from today, which is May 2nd at 1:30 in the afternoon. That's an evidentiary hearing. If you haven't been through it before, your lawyer will explain to you the day before what's going to happen at your bail hearing the next day. You may or may not be found eligible for bail in this new case in a week, but you're not eligible today. I have to hold you by law. So everything is on your paperwork. If you step to your left, she's going to give you a copy of that paperwork. Okay. Thank you. Ms. Reyes, Sadie Reyes. And then Lauren Haley, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth, please?
Sadie Reyes, 10/2001.
October 2nd? Okay, thanks. You are here on a total of 5 matters. I'm going to start with your new arrest, which is number 38 on the calendar. You were booked in on allegations of theft by control of stolen property worth $4,000 or more. That's a Class 3 felony. Possession of narcotic drugs, a Class 4 felony. Possession of drug paraphernalia, a Class 6 felony. And unlawful use of a means of transportation as a passenger, that's a Class 6 felony. There is probable cause for all of those, and I am appointing a lawyer to represent you. You'll have the same lawyer in this case that you do for your other open case, which is number 42 on the calendar. In that case, you've been charged with narcotic drug possession, a Class 4 felony, and drug paraphernalia possession, a Class 6 felony. You failed to appear at your sentencing hearing on March 13th of this year, and there was a warrant issued for your arrest. But that case remains open and pending. You're also here on 1, 2, 3 probation matters because the hearing you failed to appear at was also your disposition hearing in all of your probation cases on March 13th, and so warrants went out for your arrest in all 3 of those cases as well. So you're going to end up with the same lawyer for everything. All right, your court dates are going to be as follows. First, in the new case, the brand new case, your status conference is this Thursday, May 1st at 8:30 in the morning, with a preliminary hearing the following Monday, May 5th at 8:30 in the morning. And then in the rest of these, okay, just 1 second. I gotta talk to my staff. Can you, hey, can you go in? So the probation ones are 37, 40, and 41, and change those to post-warrant status conference, because she's not going to get sentenced that day. 42 is done correctly, it's post-warrant status conference, but she's going to Judge Kramer, and so I don't want them to think that they have a dispo that day. It's just post-warrant status conference. Okay, because the court's not going to go to sentencing, nor would your lawyer want to. If you have an open case, we resolve everything together. So it's just going to be a status conference in front of your sentencing judge to figure out where everything is at and set some dates. So for all of your probation cases and the pending case, your next court date in that is going to be in front of Judge Kramer on April 30th, which is Wednesday, April 30th, 8:30 in the morning for a status conference. All right, now in the brand new case from yesterday, because there is probable cause for new felonies while you have an open and pending felony case, that's your sentencing case, you are not eligible for bail today. You are held no bond, but you do get a bail hearing. Your bail hearing will be in 1 week. It is May 2nd at 1:30 in the afternoon. You may or may not be found eligible for bail next week, but you are not eligible today. In the new case, you are held without bond. In your two probation cases that are not Prop 200 cases, that's numbers 37 and 40 on the calendar, the court finds that they're, in all reasonable probability, you're going to be revoked to prison in those cases. And so you're held without bond. You do not have bond in either of those cases either. And then in the warrant case, your sentencing case, I'm just going to affirm Judge Kramer's bond. That was $3,000 secured plus release conditions. And in your Proposition 200 probation case, you are entitled to bond. So I'm setting what's called a placeholder bond. It's $100. It's there to make you eligible for credit for time in custody. So don't post any bond unless you're sure you're able to get out on everything. Because right now you're non-bondable in 3 cases. So just make sure if you do try to post bond that everything's taken care of. Everything's going to be on your paperwork. We did have to reprint a couple to correct the hearing type. So once that's sorted out, we're going to send it out to you. If you go ahead and have a seat, we'll send that out to you. Thank you. All right. Pardon me. Then we have Lauren Haley, please. All righty. Can I have your full name and date of birth, please?
Lauren Kate Haley, 5986.
Okay, thank you. You are here on an arrest warrant for an older case. It's because the county attorney's office has now charged you, and let me look at the docket and see how that went down. It looks like, right, they filed a complaint, somebody filed a motion to quash, and then there was a hearing set, I think, on the motion to quash. I'm just going to read what they said.
I think it's on May 13th.
Yep, May 13th. All right. So, in this case, you've been charged with 2 counts of aggravated driving under the influence of alcohol or drugs, with an alleged offense date of June 13th of 2024. This warrant was issued November 1st of 2024, and looks like these come out of the Mesa Police Department. So again, the alleged offense date is June 13th of 2024. And you may already know the significance of that, you may not. I'm going to explain it to you, though, in a moment. So I am appointing a lawyer for you, unless you hired one. Did you hire one? I hired one. Okay. Hang on, we're going to have to reprint this one. So I'm going to not appoint a lawyer for you. Okay. If at any point you want to try to qualify, you can do the financial affidavit later as well. Okay. All right, so we do need to reprint hers. I'm not appointing a lawyer for you, but you definitely need to reach out to your lawyer right away because I'm setting 3 court dates for you. The first is a status conference, Thursday, May 1st at 8:30. Your preliminary hearing will be the following Monday, May 5th at 8:30. And then, because this offense is alleged to have occurred in the window when you had not yet been sentenced on your probation case, you were on release in a pending felony case at the time this was allegedly committed. And that does trigger the Arizona Constitution and the no bond rule. So I must hold you, by law, I must hold you without bail and set a bail hearing for you. You may or may not be found eligible for bail, and in your circumstances, you got a reasonable possibility that the court will find you eligible for bail next week. That I don't make that decision. If there's probable cause and the timing is such, I must hold you without bail. So, but call your lawyer. Be sure and let them know the court dates and that they need to be in court on the 1st. Maybe they can cut a deal with the prosecutor on the 1st if you're doing well on probation. And anyway, so you're not the first person this has ever happened to. I'm glad you know about it because most people are very, very mad when they find out. Yeah. Alrighty. May 2nd at 1:30. That's exactly 1 week from today. It's the evidentiary hearing. That's your bail hearing. Okay. And then you just go sit and wait. So, okay. Sorry. It's okay. Good luck, ma'am. Keep doing well on probation. That can only help you. See if you can get to your PO from jail, but they'll know you got arrested. All right. Thank you. All right, Ruben Reese, will you please come to the podium? And then Jonathan Valdez, will you go to the chair? Where's Mr. Reese? Ruben? I don't see him. Oh, here he comes. Okay. Right here, sir. All right. Good morning, sir. May I have your full name and your date of birth, please?
Yes, good morning. Ruben Reese, and then 11/20/06.
11/20/06?
Yeah.
Okay, thank you. All right, 1 second. I just need to finish reading one more thing. All right. All right, Mr. Reese, you were arrested on one allegation of murder in the 2nd degree. That is a Class 1 felony. Based on what the police submitted, there is probable cause for that, and I am appointing a lawyer for you. Your next court date is going to be a status conference, and that will be May 1st at 8:30 in the morning in the downtown Superior Court with a preliminary hearing, May 5th at 8:30. That will all be on your paperwork. You don't have to try to remember it.
Okay.
And based on what's been alleged against you, this court sets bail in the amount of $500,000 secured. I will let you know the state recommended $1 million cash, which is a bond that the court sets in murder cases. But on the exact facts in your case and what is known about you, this court believes that $500,000 secured is sufficient. I'm also going to put you on an ankle monitor if you do post it. Secured means you can use a bail bondsman. Everything is going to be on your paperwork, but your terms of release include, and this applies whether you're in or out of jail, no contact with the alleged victim's next of kin. No, you can't respond to any contacts from them. No weapons, no drugs, no alcohol. You're under 21. If you're out of custody, you cannot go to the scene of the alleged crime. Whether you're in custody or not, if you end up with any co-defendants, and you may, no contact with them either, no contact with any of the witnesses in the case. Everything you need to know is on your paperwork, and you're going to be back in court next Thursday. Everything is on your paperwork, so if you step to your left.
Thank you. You have a good night.
You too, sir. Mr. Valdez, and then Daniel Borja, will you go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Good morning, Your Honor. Jonathan Gaitan Valdez, December 19, 2006.
Okay, thanks. Mr. Valdez, you're here on a grand jury warrant because you've been indicted in a case which I think appears to be the same one that you had charged against you about a month ago. And the charges from the grand jury are armed robbery, a Class 2 felony, kidnapping, a Class 2 felony, aggravated robbery, a Class 3 felony, 3 counts of aggravated assault with a deadly weapon or dangerous instrument. Those are Class 3 felonies. 1 count of possession of a weapon by a prohibited person. That's a Class 4 felony. And carrying a deadly weapon under the age of 21 years. I believe that's a concealment charge. In any event, it's a misdemeanor. It's Class 3 misdemeanor weapons charge for being under 21. The alleged offense date for most of those is March 25th of 2025. The weapons possession, Class 4 felony, and the under 21 weapons charge, the Class 3 misdemeanor, those appear to be April 14th of 2025. All right, I am appointing a lawyer for you. It should be the same lawyer that you just had because I checked on your other case. This is how it works. There is a dismissal order on file for that case. It was today or yesterday, I don't remember. So now you're charged in this case. So this appears to just be take over for the old case. So it would be highly likely you're going to end up with the same lawyer. But the legal defender will decide. So you're going to be arraigned May 2nd, which is 1 week from today, 8:30 in the morning in the downtown Superior Court, and you have the same release conditions that you had in that earlier charged case, and that is $75,000 secured appearance bond, ankle monitor if you post it, no contact with any alleged victims, witnesses, or co-defendants. You have at least one co-defendant because you're co-defendant number 2. No weapons, no drugs, no alcohol. If you're out of custody, do not go to the scene of the alleged crime. Everything's on your paperwork. If you step to your left, he's going to give you a copy.
Thank you.
All right, thank you. Mr. Borja. And then Dwight Miles, will you go to the chair, please? Hello, sir. Can I have your full name and your date of birth, please?
Daniel Borja, 6791.
Thank you. You are here on a new case. You were arrested for theft by control of stolen property and worth $4,000 or more, 3 counts of aggravated assault by the impeding of breathing or strangulation in a domestic relationship. Those are all Class 4 felonies. 1 count of disorderly conduct, a Class 1 misdemeanor. 1 allegation of preventing or interfering with the use of a telephone during an emergency, and that's a Class 2 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your status conference in this case will be this Thursday, May 1st at 8:30 in the morning, with a preliminary hearing May 5th at 8:30 in the same court. In your case, based on your criminal history and what's been alleged against you, as well as the risk assessment score the court finds, there are major indications that you pose a severe risk to this alleged victim. So based on that, the court sets bail in the amount of $50,000. It is secured. If you post it, you will be on pretrial services with alcohol testing and monitoring. You may not go to the scene of the alleged crimes. If you've been living there, you can do a civil standby to collect. No, you haven't been. According to the police, you said you had not been.
No.
You may categorically not go there. No weapons, no drugs, no alcohol. You may not initiate any contact with her. You may not respond to any contact from her. No weapons, no drugs, no alcohol. If you were served with an order of protection, you must comply with that as well. Also, I included a felony statute for you to look up once you have access to a computer. That is the aggravated harassment statute. It says that one act of harassment committed in violation of a no contact order in a criminal case can be booked as a felony. One act, that can be one text that says I love you. If a court finds that was harassment, you will be non-bondable. You will get held no bond. And people who I worry very much about violating release conditions or committing or making attempts to intimidate or retaliate against a victim, I tell them, look it up. One time you could get you held non-bondable in this case. And I tell people that because I think it might make them slightly more likely not to violate release conditions. Everything you need to know is on your paperwork. If you step to your left, the officer's going to give you a copy.
So the bond, I can't cut that in half at 25?
This court is not here to negotiate with you, Mr. Borgia. This court is concerned that you're going to murder this woman because one instance of domestic strangulation means she is 7 times more likely to ultimately be murdered by you. They allege 3 separate instances. They allege an ongoing altercation, and they actually allege that it's not your first rodeo for this. So the court is extremely concerned that you may attempt to intimidate her, retaliate against her, and that even statistically speaking, you are far more likely to end up killing her one day. That is the reason for the bond amount and the ankle monitor. Talk to your lawyer. There's substantial research correlating domestic strangulation and murder. So talk to your lawyer about that. If you step to your left, you get a copy of the paper.
Yes, Your Honor.
Thanks. Mr. Miles, Dwight Miles. Hello, sir. Can I have your full name and date of birth, please?
Dwight Miles, 2007.
February 17th?
Yes, sir.
All right, thank you. You're here on a grand jury warrant because you've been indicted in a case from last year. Indicted means the grand jury met, they heard evidence, and they found probable cause to formally charge you with armed robbery, a Class 2 felony, and aggravated robbery, a Class 3 felony. The alleged offense date is November 14th of 2024. This comes out of the Gilbert Police Department. You'll get a copy of those charges and police reports from your lawyer. I am appointing a lawyer for you. The next court date is an arraignment hearing 1 week from today, which is May 2nd at 8:30 in the morning in the downtown Superior Court. I'm affirming the bond set by the grand jury judge, which is $25,000. It is secured. If you bond out, be sure to comply with all of your written conditions. Don't go to the scene of the alleged crime. No weapons, no drugs, no alcohol. No contact with any co-defendants, whether you are in or out of custody. No contact with any alleged victims, whether you are in or out of custody. Everything's on your paperwork. If you step to your left, you get a copy of that. Mr. Cool, Mark Cool. And then Caitlin Dexter. We go to the chair, please. Hello, sir. Can I have your full name and your date of birth, please?
Mark Edward Cool, 1780.
Thank you. You're here on a grand jury warrant because you've been indicted in a case from last year. The charge is theft of a means of transportation, a Class 3 felony, and the alleged offense date is July 30th of 2024, and it looks like this comes out of the Department of Public Safety. If that doesn't ring any bells, you will get a copy of the police reports and the charge from your lawyer, and I am appointing a lawyer for you. All right, and it looks like your arraignment hearing is 1 week from today. May 2nd, 8:30 in the morning. I'm affirming the bond set out of the grand jury, which is $10,000 secured with release conditions that include no contact with any alleged victim. If you're out of custody, don't go to the scene of the alleged crime. No weapons, no drugs, and then a valid prescription, and call your PO within 72 hours of any release from jail. I know you're stuck in on other stuff. This bond goes on top of whatever other bonds or holds that you have.
Will the cases go together, though?
Yeah, talk to your lawyer. You're going to end up with the same lawyer. It looks like you've got probation violation pending, and is it 2 cases, I think?
Yes, 2 separate.
So probation court lawyers don't normally take trial cases, so probably what's going to happen is now you're going to go to a trial attorney, and they'll get your probation matters too. Okay. And so, and they'll work on the, they always try to work on a global resolution. Right. All right. If you step to your left, you get your paperwork.
Okay, thank you.
Sure. Ms. Dexter, Caitlin Dexter, and then Clinton Kerber. We go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Caitlin Portia Dexter, 63690.
All right, thanks. You're here on 2 probation violation warrants. You're on probation for a Class 2 felony and a Class 6 felony. There were warrants out for your arrest in both of these cases because on December 12th of last year, there were petitions to revoke your probation filed in both cases. And, just a second, I need a copy of it. It's not in the usual spot. Okay, here's one. All right, the petitions allege that you violated terms 3 and 5. You'll get a copy of those petitions from your lawyer. I'm appointing a lawyer for you in both cases. Your next court date will be the same for both cases. It's this coming Thursday in the downtown probation court, which is May 1st at 8:30 in the morning. That's a revocation, arraignment, and possible disposition hearing. I'm affirming the bonds set by the probation judge. So in the Class 2 felony case, that is $5,000 secured. In the Class 6 felony case, it's $250 secured. So $5,250. If you bond out, comply with all of your written conditions and call your PO within 72 hours. You step to your left, he's got your paperwork for you. Mr. Kerber. And Joshua Nord, will you go to the chair, please? Good morning, sir. May I have your full name and your date of birth, please?
Ray Kerber, 11-481.
Thank you. You're here on a new case. You were arrested for criminal trespass in the first degree. It is a Class 6 felony, and there is probable cause for it. I am appointing a lawyer for you. Your status conference will be this Thursday, May 1st at 8:30 in the morning with a preliminary hearing May 5th at 8:30 in the morning in the downtown Superior Court. Now, in your case, the court is aware from having read the probable cause statement that you are likely to assert at trial or even in this courtroom that you have an absolute right to go to that location. It appears there's probable cause at least that you do not. So I'm going to issue court orders in your case. They apply whether you are ultimately acquitted in the case or not. So these court orders, if you violate them, even in a case in which you are ultimately acquitted at trial, you will be held accountable for violating the court orders. The court orders apply.
Can I tell you what the deal is? No. Okay.
I'll give you a chance to talk in a minute.
Okay.
I will. But I want you to listen to me, because what I'm trying to tell you is the police went into some detail about your claims that you have the right to be there and about your adamant refusal to leave the premises when they told you to. The court takes that as a strong indication that you will go straight back there while the case is pending, that you will not respect release conditions, and this is a vulnerable victim.
I wasn't going to go straight back there. I was going to go to court via the...
Great. So I'm going to tell you what my orders are.
Okay.
I'm not negotiating with you about my orders, and then I'll let you say what you have to say.
Okay.
The court is very concerned that this is a vulnerable victim. So, bond is set in your case at $2,500. It is secured. If you bond out, you go on an ankle monitor to keep you honest about not going there without court permission. Now, what you can do is a civil standby with a law enforcement officer. That means you request, sir, you're not listening.
I'm listening.
Request a civil standby through the Phoenix PD. They will send an officer to go with you before you get there. You do not go to that location on your own. The cop will keep the peace while you collect some belongings. But categorically, you may not go there unless there's an officer standing with you. We see people in situations like this sometimes, and they're back literally the next day. So you may not give yourself permission to go there in violation of the court's order. Absolutely no contact with the alleged victim. No weapons, no drugs without a valid prescription. If you get served with an order of protection or order against harassment, you have to comply with that as well. Those are the court's orders. Now, if you're going to tell me that you have an agreement with Gloria to continue living with her and all of those things, the police have gone into a fair amount of detail about that. I will give you a minute to tell me anything that you think would affect my release decision. Sure. Go ahead.
Okay, so I entered a lease agreement with Gloria
Yes, I know, sir. This is what they told me. What I'm saying is, what else do you have to tell me? I understand you assert that you have a lease agreement.
I do, and last time I paid rent was on May 8th of this year, at which point she gave me a 30-day, we're not going to continue.
Eviction notice is what it's called.
It's not an eviction. It wasn't from the court. That's what it was titled, but it's not. It's just a 30-day, we're not going to continue. It was not a court document at all. Okay, so as the law states, you get your 30-day, you pay your rent, and then we're not going to continue in 30 days, right? And then she can file for an eviction. She's not filed for an eviction of any kind with the court. She has a history of being on and off again, with me. In February, she falsely accused me of assault.
Mr. Kerber,
yes?
I am not here to litigate your case.
I know that.
Stop, listen, okay? Okay. The purpose of this hearing is to test what the police have alleged.
Okay, I'll tell you what happened.
Just a second.
Okay.
It's not to determine or resolve the case. Probable cause is far below beyond a reasonable doubt. This is what I want to know, Mr. Kerber.
Yes.
Do you understand the difference between the civil case that you're talking about and
Yes.
this criminal case? Do you understand? Because I don't
that.
think you do. You're telling me things,
do.
Mr. Kerber. Part of the reason that the court is going to set a bond and put you on an ankle monitor is because this court believes that you think any of that changes the validity of this court's orders. It doesn't. So, Mr. Kerber, why are you telling it to me if you don't believe that it changes the validity?
I just wanted to get...
Mr. Kerber, I'm going to try one more time to get you to listen.
I'm listening.
Don't speak until I point at you, okay? All right. So, Mr. Kerber, among the things going on, the police allege that they told you to vacate, they gave you an opportunity, and to their faces, you refused. And now, what I'm trying to tell you, Mr. Kerber, on that allegation, and in fact, your demeanor and behavior here in court, this court strongly believes you will not respect these court orders.
I will.
I don't have a basis to believe that. I did. So, Mr. Kerber, I'm going to give you one more chance. If you try to litigate the underlying validity of your lease, I'm going to cut you off because that does not rebut the probable cause for this case. This court believes she had the categorical right to tell you to get out, lease agreement or not lease agreement, and that you began trespassing when you didn't vacate.
That's not what happened. So what happened was I was trying to show the police the law, right? We were on the public sidewalk, okay? The police officer said, okay, well, I'm going to formally trespass you. Are you going to leave? While still on the public sidewalk, never stepped that foot back on the property, and I said, I would like to talk to your supervisor. I didn't say I wasn't going to leave. I just, on the public sidewalk, I said, I would like to talk to your supervisor. I did not go back onto the property. I did not say I was going to go back on the property. I said, I would like to talk to your supervisor. And he said, okay, we're going to arrest you. And then they arrested me. Within 10 seconds of telling me I was trespassed on the public sidewalk, while still on the public sidewalk, he said he was going to arrest me because I asked to talk to the supervisor. That was all that happened. I never...
alleged that you categorically refused.
I did not categorically refuse. I wasn't even on the property.
Okay. And then they say, he said that if I arrest him, he would sue me as he is allowed to be inside this residence. So,
I said that he would be liable if he arrested me because it's an unlawful arrest because I'm on a public sidewalk.
All right. Explain to me what you think that you're going to have to do in this case once you are ultimately released and it remains pending.
So when I'm released, I was going to call my friend.
No, I don't want to know what you're going to do. What do you understand my court orders to be?
Oh, the court orders, don't go back to the property. Okay. Don't go back to the property no matter what, and go to your court dates and
Can you have contact with her?
No, of course not.
You can serve legal process on her, which means you could, if you file a lawsuit or something, you can't personally serve it on her, by the way.
Of course not. No.
Permitted under civil rules, but you can have a process server serve her.
Of course.
You can do that. Yes. Anything else violates these orders.
I wasn't going to have any contact with her. I wasn't going to personally go back there. I was going to go to my friend's house, and then I was going to go to the local court and see what I could do in filing a lawsuit.
Do you know what a civil standby is?
Yes.
What is it?
It's where you go with a police officer to get your property.
Are you allowed to do that?
I mean, I don't even know.
Yes, I did say that you were allowed to do that.
I wouldn't even risk that. I would maybe have a friend or something go to get my property.
You can't send a friend. That's sending a third party. Although I will say, if you have a friend you think could peaceably do it, but I doubt it on these facts. If that friend gets told to leave, that friend has to leave.
Okay.
So, all right, what I'll do though is I will take away the bond. I'm going to put you on the ankle monitor though. You have prior felonies. They're old, but there are 3 of them. And this again is a vulnerable victim. So what I just need to understand, and it sounds like you do, is that you actually understand that it doesn't matter whether you ultimately win this case. You can't violate the orders while it's pending. The orders are there to keep the peace. I do not decide whether you did this. I make orders that I believe will keep the victim safe, keep you compliant, and keep you showing up with court orders. So I'm willing to give you a try without a bond to make it more important to you because you're telling me that you understand and you will comply. You're going to get an ankle monitor though because I'm worried that you'll do some self-help after you get out of this.
I have
So,
enough time.
know that if you come in on this identical offense, meaning if you go there without a cop, you could be arrested for felony trespass, you'll get held no bond. It just happened to a bunch of people, because you'll be in on a new felony allegation while you have a pending felony case. So one arrest at that location while this case is pending can land you in this jail, held no bond for at least 1 week and possibly the whole case. Okay. That is a large hammer that I think will help enforce your compliance, but I'm willing to let you be out of custody. They do not allege that you have been violent toward this person. So I'm going to put you on an ankle monitor. Okay. You must comply, but I'm not going to make you post a bond. Okay. That's going to change your court dates. So your court dates are going to go to out-of-custody court dates. The first one is May 9. So that's 2 weeks from today, May 9 at 8:30 in the morning. Preliminary hearing, May 13 at 8:30. Everything is on your paperwork. It is critically important that you respect the release conditions. Sure. You may yet win your civil case. You may beat this criminal case, but you must not violate release conditions.
I have a quick question. So in winning, if I were to win this civil case,
has nothing to do with the criminal case.
I still can't go back there.
Until you got a different order in the criminal case, these orders apply. You can talk to your lawyer about a motion to modify these orders. You're allowed to do that. Okay. But you can't violate them while you're waiting for the ruling. And keep in mind that if you were to do one thing, I told somebody earlier, one act, if a court found it was probable cause for harassment, because there's a no contact order in a criminal case, that's felony harassment. So you cannot send her one text to say, where's my stuff, or something that seems innocuous. If that's found to be harassment, you still get held no bond on it. And that applies even if the underlying case gets dismissed. So talk to your lawyer. It is critically important that you comply with release conditions. As I said, I do not decide whether you did this, just whether the police have shown probable cause. They have. What you're telling me did not rebut probable cause. It doesn't mean you couldn't beat the case. It just means it doesn't rebut probable cause. I know that's somewhat complicated. I did give you a lawyer to help you. Just don't violate the conditions while the case is pending. If you want them changed, talk to your lawyer about filing a motion to change them. Yes. Don't help yourself to things that you like better. Okay. I know it's inconvenient and difficult. I did give you a civil standby, because people have things like medicine and keys and important.
Well, I have all my property there, man.
Right. Yeah. So we find that if we don't allow you to do a civil standby, people are going to do it anyway. So I want to give you a legal way to do it. It's with a cop standing next to you. Yeah. So everything is very, very clear, I think. You seem to understand it. I'm willing to give you a try on just an ankle monitor. You have to be hooked up to that. That's going to be later this afternoon, and you get out after the ankle monitor is put on. Everything will be explained to you by the monitoring officers when they put it on your ankle. Okay. All right? If you step to your left, you get your paperwork. Thank you. Mr. North. Then Eleazar Candela. Hello, sir. Can I have your full name and your date of birth, please?
Judge Minori, 6/14/1882.
All right, thanks. You are here on 2 bench warrants and a warrant from Pinal County Superior Court. All right. In Maricopa County, you've been charged in 2 different criminal cases, and you failed to appear at your sentencing on March 3rd of this year. In the first case, number 21 on the calendar, you've been charged with narcotic drug possession and drug paraphernalia possession. That's a Class 4 and a Class 6 felony, respectively. In number 22, you've been charged with dangerous drug possession and 2 counts of narcotic drug possession. Those are Class 4s, and drug paraphernalia possession, Class 6. You've already had a lawyer appointed in those cases. So what we're going to do is give you a status conference in front of Judge Kramer, who is your sentencing judge. That's going to be May 5th. So a week from Monday, May 5th at 8:30 in the morning. And I'm affirming Judge Kramer's bonds in those cases, which is $1,000 secured per case for $2,000 total. There's also a warrant out for you from Pinal County. It's a failure to appear warrant. You've been charged there with 2 counts of theft of means of transportation. Those are Class 3 felonies. This warrant was issued February 18th of 2025.
Man, can I make
not yet. Just let me finish. Okay. I'm going to let them know they should give you a lawyer if they have not done that already. Your court date in Pinal is scheduled for Wednesday, April 30th at 8:30 in the morning. And I'm going to affirm Judge Neal's bond out of Pinal County. That's $2,500 secured with written conditions. Now, what did you want to say?
I've never been to Pinal County, so I'm not sure where that even came from to begin with.
I don't test that. What I see is that Joshua Lee Nord, born on your birthday, hitting on your fingerprint record, has been charged. So you get to go find out.
Yeah, my fingerprint record.
Meaning, Pinal put it into the nationwide system on the criminal record that pertains to your fingerprints. That's not absolute proof of identity. One of the things that has to be proved against you in any criminal case is identity.
Right.
Identity is a defense. So talk to your lawyer, but I don't test whether this is you at the initial appearance. There's a valid warrant in the system for the arrest of the person whose criminal history this pertains to. That's not categorical evidence that you did the crime.
Right.
Talk to your lawyer about an identity defense, but you'll get the police reports. You'll get all of that, and if you haven't ever been to Pinal on this case, I did remind them to give you a lawyer when you get there, which I'm sure they would have.
Okay.
But the Maricopa lawyers here for your sentencing cases, they can't represent you in Pinal County. Right. You have to get a Pinal lawyer.
Okay.
So talk to your lawyer in the Maricopa cases. County to county, maybe they can do a global resolution, maybe they can't, but talk to your lawyer about that here in Maricopa,
Okay.
Which is the 5th, though. So if you bond out, so your total bond is $4,500. If you bond out, you're going to have to be down in Pinal on April 30th and then back up to Maricopa on May 5th.
Okay.
Everything's on your paperwork.
Thank you.
Mr. Candela, and then Scott Sticka, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
January 27, 1997.
Are you Eleazar Candela?
Yeah.
Thank you. You've been arrested again for aggravated domestic violence, a Class 5 felony, and disobeying a court order, a Class 1 misdemeanor. There is probable cause for both of those, and I am appointing a lawyer to represent you. Your status conference is going to be May 1st at 8:30 in the morning, which is this Thursday, with a preliminary hearing May 5th at 8:30 in the same court. And I'm well aware of the 6 times you've been accused of violating this order of protection since it was served on you. I'm well aware that the last 2 times you were booked for aggravated domestic violence, in this case, the county attorney declined to file the charges. This court believes that on these facts, you are extremely likely to violate release conditions and violate this court order again. And this court does not decide what cases the county attorney wants to charge or doesn't want to charge. But in this case, the court believes there is ample evidence that you committed aggravated domestic violence, and you're very likely to do it again while the case is pending. So bond is set in your case at $2,500. It is secured. You may not go to the scene of the alleged crimes. You may not have any contact with the alleged victim. You may not respond to any contact from him. So if he invites you to come home, you literally can't talk to him. He cannot give you permission to violate a court order. No weapons, no drugs, no alcohol. I've listed every one of your booking numbers by date and by booking number for prior violations of this order of protection. I don't know why the county attorney has not filed against you. Perhaps this will be the time. They get to decide between now and 48 hours from now if they're going to file the charges. You've been through this twice before this year alone. So I know you know how this works. So that is why the bond. And if they do file and you bond out, be sure to comply with all of your written conditions. If you don't bond out, do not try to contact the alleged victim from jail. You are prohibited from doing that. If you step to your left, you get a copy of your paperwork. Mr. Sticka? And then Christopher Lales, we go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
Scott James Stigger, 82673.
All right, thank you. You're here on a bench warrant from the Superior Court in 2 different cases, and it looks like it was a failure to appear at sentencing on February 24th, 2025. In number 3 on the calendar, you've been charged with dangerous and narcotic drug possession. Those are Class 4 felonies, and drug paraphernalia possession, a Class 6 felony. In number 2 on the calendar, you've been charged with drug paraphernalia possession, or maybe that's what you pled guilty. No, sorry. This is your disposition hearing for probation. You're on probation for a Class 6 felony, and so you failed to appear at disposition on the same date as your sentence.
Yes, ma'am.
All right. You have a lawyer for both cases. We're going to give you a status conference in front of your sentencing judge. That's going to be this Thursday, May 1st at 8:30 in the morning. She will give you a sentencing date when you get there on May 1st. Then they'll set your sentencing date. All right, I'm going to affirm her bonds. In number 2 on the calendar, it is a $1,000 secured appearance bond. That's your probation case. Oh, I'm sorry, it's cash only. She orders cash only at sentencing. So $1,000 cash only in the probation case, $500 cash only in the pending felony drug sentencing. So that's $1,500 cash. If you bond out, comply with all of your written conditions. If you step to your left, you get a copy of that paperwork. Thank you. Mr. Leos, and then Jasmine Hernandez, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
7/26/1995.
All right, thank you. You are here on a probation violation warrant. You're on probation for a Class 6 felony. There was a petition to revoke your probation filed on February 26th. It alleges that you violated terms 3, 4, 5, 7, 14, and 15. You'll get a copy of that from your lawyer. I am appointing a lawyer for you. Your next court date is in the downtown probation court this Thursday, May 1st at 8:30 in the morning. It's a revocation, arraignment, and possible disposition hearing. The address is on your paperwork. I'm affirming the bond set by the probation court, and that is $900 secured. If you bond out, comply with all of your written conditions and call your PO within 72 hours. This gentleman has your paperwork for you. Thank you. Ms. Hernandez? And then William Coster, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Jasmine Hernandez, May 2nd, 2002.
All right, thank you. You're here on a warrant for failing to appear at a status conference in a case in which you've been charged with possession of narcotic drugs, a Class 4 felony. This issued back on September 12th, 2022. You've already had a lawyer appointed. Your status conference is going to be Thursday, May 1st at 8:30 in the morning with a preliminary hearing May 5th at 8:30 in the morning. And I'm going to affirm the bond. No, I'm sorry, I'm not. I'm raising the bond because I'm considering the age of the warrant, and that is $750 secured. That is your bond, $750 secured. If you post it, comply with all of your written conditions, and you're not on probation, so just come to all of your court dates. Everything's on your paperwork. If you step to your left.
Question. Have to pay a bond now?
Correct. You don't get out of the jail. You can pay it next week, but you don't leave the jail until another judge lets you out or you bond out. All right, Mr. Coster?
Thank you.
Thank you, ma'am. And then Samantha Burton, we go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
May I please address the court after?
Not yet. No, I need your full name and date of birth,
Yes,
please.
my name is William Costa. My date of birth is 4/15/73.
All right. I'm going to tell you why you're here and do the things that I am required to do by law, and then I'll give you a chance to talk.
Thank you, ma'am.
You're here on 3 matters. The first one is a new case. You've been arrested for possession of narcotic drugs, a Class 4 felony. I'm appointing a lawyer for you in the case and giving you court dates as follows. That's a status conference, May 9th at 8:30, and a preliminary hearing, May 13th at 8:30. Those will be in the downtown Superior Court. You're also here on 2 probation warrants because on February 28th of this year, there were probation violation, petitions to revoke your probation filed in both of your cases. They allege that you violated terms 3, 4, 7, and 15 of your intensive probation. And your next court date will be in the downtown probation court, May 1st, which is this Thursday at 8:30 in the morning. Now, in each of the probation cases, I'm planning to affirm the bond set by the probation judge, which is $500 secured per case for $1,000 total. In the new case, I did not find probable cause for the drug possession because the police appear to have booked you on the wrong kind of drug. They allege that you had something like methamphetamine, but they booked you for a narcotic drug. So that is basically they messed up the booking. It does not mean it's dismissed. It means I'm not setting release conditions for it, which is why you're being released in the new case with court dates and a lawyer. In the probation cases, I'm affirming the $500 bond. Now, what did you want to say?
Oh, no, since I have a bond, I'm going to keep my mouth shut, ma'am.
Okay. You step to your left. It's $1,000 total. If you bond out, call your PO within 24 hours, okay?
Okay,
All right.
Thank you, ma'am.
Thank you. Ms. Burton? And then Abinati Ayala, we go to the chair. Hello, ma'am. May I have your full name and your date of birth, please?
Samantha Burton, 7/12/84.
All right, thank you. You are here on a probation violation warrant. You're on probation for a felony, and back on June 27th of last year, there was another petition to revoke your probation filed. It alleges that you violated terms 3, 4, 5, and 15. You get a copy of it from your lawyer, and I am appointing a lawyer for you in probation court. The next court date is this Thursday, May 1st at 8:30 in the morning. That's a revocation, arraignment, and possible disposition hearing. The address will be on your paperwork. And in this case, I'm affirming the bond set by the judge who issued the warrant, and that is $500 secured with written conditions. If you bond out, comply with all of them, call your PO within 72 hours. Okay. This man has your paperwork. Mr. Ayala, and then Corey Garskowicz. I'm sure I messed that up, but Corey, will you go to the chair, please? Hello, sir. Can I have your full name and your date of birth, please?
Benedict Ayala, March 16, 1983.
All right, thank you. You're here on a probation violation warrant. You're on probation for a class. a Class 6 felony, and there was a petition to revoke your probation filed on November 22nd of last year. It alleges that you violated terms 3 and 5. You get a copy of it from your lawyer. I am appointing a lawyer for you. The court date is in the downtown probation court this Thursday, May 1st at 8:30 in the morning. That's a revocation, arraignment, and possible disposition hearing. The address is on your paperwork, your bond. I'm just affirming it. It is $250 secured. If you bond out, comply with all of your written conditions and don't miss your court date. If you step to your left, they're going to give you that paperwork. Thank you. Mr. Garskowitz? Corey? Any Corey, please? He's got like a little beard, officer. He's about 45 years old. That's him right there in the gray t-shirt. That's him. And then Christopher Frederick. So we go to the chair. You'll be next. Right here, sir. Good afternoon, sir. Can I have your full name and date of birth, please?
Corey Ronald Garskowitz,
What's your date of birth, sir?
June 15, 78.
All right, thank you. You're here on a probation warrant. You're on probation for a Class 6 felony, and there was a petition to revoke your probation filed on February 27th of this year. The petition alleges that you violated terms 3, 4, and 5. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your next court date is in the downtown probation court this Thursday, May 1st at 8:30 in the morning. The court address will be on your paperwork. Your bond is $250. It is secured. If you bond out, comply with all of your written release conditions, call your PO within 72 hours of any release. The number is on your paperwork. If you step to your left, the officer has that paperwork for you. Thank you.
When will I be released?
Well, if you bond out, you get released. If you don't bond out, you'll go to court on May 1st, and you may or may not be released then. You have to talk to your lawyer and the probation judge on May 1st. But if you bond out, don't miss your court dates, okay?
Okay.
All right, he's got your paperwork.
Thank you.
Thank you. All right, Mr. Fredericks, and after that, Jerome Schussler. Please go to the chair. Where is young Mr. Fredericks? Did I skip somebody? Oh. Right here, sir. Mr. Fredericks? Yes, sir. Can you take your hood down, please? All right, thank you. All right, sir, I need your full name and your date of birth, please.
Christopher Michael Fredericks, December 4th, 2004.
All right, thank you. You are here on a probation warrant. You're on probation for a Class 6 felony, and there was a petition to revoke your probation filed on January 5th of this year. It alleges that you violated terms 3 and 5. Mr. Fredericks, I need you to stand up. All right. Yes. I'm appointing a lawyer for you. You get a copy of the petition from your lawyer. Your court date is this Thursday, May 1st at 8:30. The address for that court date is on your paperwork. You have a $250 secured bond. If you bond out, get yourself to court on Thursday. There'll be a warrant issued for your arrest. If you don't bond out, the sheriff will take you over there. You can meet with your lawyer and the probation judge. If you step to your left, he's got your paperwork. Good luck.
Thank you. Thank you, Judge.
Mr. Schussler, and then Glenn Wingfield. We go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
How you doing, Your Honor?
I'm all right, thank you. What's
My
your
name is Jerome Schussler, 381.
All right, thanks. You're here on a new case. As I'm sure you're aware, you got booked in for possession of dangerous drugs. Wait for it. A Class 4 felony. Can you ever trouble hearing?
I have a hard time hearing.
Okay. That you don't have to wait for. Can we get headphones? Yeah.
I just can't hear real well.
Okay, we're going to, Sir, Mr. Schussler, we're going to get you headphones.
Oh, yeah.
Okay. Okay, I'm going to speak quietly so it doesn't blow you out, but give me a thumbs. Will you turn it up a little, officer? He's pressing, I think, because he can't hear it. We're showing how to do it. Turn it up. I'm going to keep talking. Can you hear me? Can you hear me? Give me a thumbs up when you get, okay, louder. Okay, more, better.
Yeah.
Keep going. Let's see. What's that? She said it's like a scroll sideways. She said, yeah, there's like a thingy. Is that better? Okay. And then, oops, too far.
Oh.
Too far. You just go and hand it to him, officer. He can do it. Yeah, there you go. Okay. All right, yeah, now you can control that. Okay. All right, thank you. And just so you know, Mr. Schussler, every superior courtroom has headphones. So just advise the lawyer or advise the judge. Every time you get into court, just say, I need headphones.
All right.
And they'll set it up for you. We all have them, okay?
Thank you.
So I think you said your name and date of birth, didn't you?
Yes.
Okay. You're here on a new case. You got arrested for possession of dangerous drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. I'm giving you a court date in 2 weeks. That's a status conference, May 9th at 8:30 in the morning, with a preliminary hearing May 13th at 8:30. And in your case, it may surprise you to know that I'm going to release you to pretrial services. You've got a serious rap sheet. That being said, in general, except way back in 2005, they are not violent offenses. And in this case, the police allege you were cooperative with their investigation. And so I'm going to give you a chance to go to court. It is true that lately, the county attorney has been known to offer people probation and a chance for drug treatment, even when they have a lot of priors. That may be you. They may offer that to you. So talk to your lawyer about that. But you'll never get that offer if you don't show up. So you got to show up. Pretrial reporting is very simple. It's pathetically simple. We're going to give you an envelope. When you get out, open the envelope, call the number, give them your name, and they will tell you when and how they want you to report. They usually just have you call, but if they want you to come in, you have to do it. Just comply with whatever they tell you. Do not miss your court dates. To the extent you have anything to bring to court to show that you are a good candidate for drug treatment, bring it and give it to your lawyer. But if you miss court, you're going to get a warrant and you're going to get a bond. And the odds of going back to prison for this start getting pretty high. So it sounds like you understand what's at stake.
I do.
You must comply. You must come to court. But I believe, based on what I'm looking at, that you're not going to be dangerous if you're out in custody, and that you're hopefully at least likely to show up to hear that offer. It's up to the county attorney what they offer you. But on a drug charge, I am willing to let you prove whether you will or won't come to court. It looks like you probably got out of prison, 2023, 2024?
Yeah.
Yeah, and that you don't want to go back. So I'm hoping that that is your motive, to show up, talk to your lawyer, defend your case, see what you can get, okay?
Thank you.
All right, no problem. All right, good luck, sir. Mr. Wingfield, Glenn Wingfield. And then Jonathan Benali. We go to the chair. Right here, sir. Hello, sir. Can I have your full name and date of birth, please?
Ronald Wingfield III, January 28, 1993.
Okay, thanks. Mr. Wingfield, you're here on a warrant from Peoria City Court.
I actually had a question about that.
I know. Hold on. I'm going to ask you a question.
Okay.
And if I can release you today, I'm going to. So take a deep breath. I want to figure out what your situation is and make sure that is the right decision, depending on whatever else you have going on. But first, I have to tell you what it is.
Okay.
So on April 16th, 2025, when you may have been in custody here, I don't know. That was a week ago. 9 days. The Peoria City Court put out a warrant for you in a criminal trespass and public consumption of alcohol case. Those are misdemeanors. So, this looks to me like a warrant that popped up while you were getting released. Am I correct?
That is actually something that I wanted to ask you about.
Okay.
It wasn't a discharge. I can bring out the charges right here if you want them.
What are you in for? Do you know what you're in for right now? Not this case, but what were you already in for?
I had disorderly conduct, but what I was already in for, there's a 2-week thing at CBI and another 2-week thing to make sure everybody's time was going coherently.
Right.
You know, I got told I had to own some shit that happened to me as a child, and from the sound of it today, it sounds like it's been going great, but it was a 2-week thing, and a 2-week thing, which kind of happened. I feel like I'm a little extorted from Scottsdale, but that's for the Peoria thing. My last charge was bundled up underneath these two with Peoria. They told me Peoria dropped it, as in like it was dismissed.
I'm trying to figure out if you were on the way to getting out today. Do we know?
Actually, yes.
So were you being processed for release when this hit? That's what I'm trying to figure out.
I got back and I was supposed to be released at 10:30 this morning, and then I got told I paid issued.
Okay. Then that's what I needed to know.
Okay.
That's what I need to know, because on this kind of charge, I'm willing to release you and let you prove whether you will or won't go to Peoria, because this is a more minor offense. We don't need to hold you. I just thought if you're stuck in on something else and I don't give you a little bond, it's going to trigger another warrant and you're going to be brought back here on page 2.
That whole thing is a funny story. You remember July 4th last year when the kids shot the president or whatever? I was in Valleywise and I had a malpractice incident, and that's why I couldn't go to because the date of that charge was not the 25th. I actually asked them over at the, when they put me to RTR, like, wasn't that last year when I was in the hospital when I couldn't show up because Peoria was reporting to me for Glendale with that warrant. That way I didn't have this happen. And by the time that I actually heard from Peoria about the warrant, it had already happened. And the judge was actually kind of excited to see me, but like I said, I barely cracked the beer that morning, and that literally, it was just like, it wasn't even that. It was.
Well, I don't decide whether you did it. It's, so you have to go to Peoria, but let me ask you, are you supposed to go straight to CBI?
Oh, no, that was handled, this charge was dropped, that's why I was like, why is it brought up? My hand's already cut.
It seems like maybe it wasn't.
July.
So what I need to know is, if I release you, are you gonna go to Peoria on May 15th at 9 in the morning to talk to the Peoria judge about this? Will you go?
May 15th?
May 15th?
Yes, no.
All right, I'm gonna release you then, because like I said, these are basic misdemeanors.
Okay.
They don't mean you're dangerous or anything. I just want you to understand that even if you think it should have been dismissed or whatever, you must go to Peoria and sort it out with them. You know what I'm saying? As long as you're telling me you will go on the 15th at 9, right? You'll go?
Okay.
Okay, then I'm going to release you.
I understand that.
Okay.
No, that is beautiful, because that's how the judge sounded every time I go to Peoria, he calls me, and I feel like he just sentenced me out and out and out, and that's why I answered honest.
Go talk to them and try to see if you can get it resolved on the 15th, one direction or the other. But if you don't go, you're going to catch another warrant. So just don't do that, all right? No, everything is on your paperwork. Okay. Don't lose your paperwork, because that tells you where to go on the 15th.
There is a paper trail with this stuff. Okay. No, is there, like, online?
I don't know what's online,
can I go to the city and go get my copies? Because I'm on the street right now, and it's hot to have. So can I get copies when, like, I go to handle everything as I need?
Well, yes, definitely always ask for that. All we have for you today is I have a release order that I want you to save. Save that, because it tells you where to go on the 15th.
Okay.
I know it can be hard to get somewhere if you don't have a regular place to stay, but this gives you 3 weeks to plan ahead, okay? Don't miss it. Call them if you think you're going to miss it.
I'll find a way to do that from the hospital. Last time I didn't have that.
All right. Well, good luck with that. All right. You can take that. You should be processed out now. Just take your orders and you're all done. All right.
Thank you.
Don't miss court.
Any advice for me with the whole situation?
Just don't miss court, okay? Don't miss court dates. That's how you land back here, okay? All right. Thank you. Mr. Bernali. All right, sir. Can I have your full name and your date of birth, please?
Jonathan Benelli, December 27, 1971.
All right, thanks. Mr. Benelli, you are here on a warrant from the state of Louisiana that issued on July 11th of 2017. It appears there that you've been convicted of the felony, I did look it up, it's a felony of obscenity. And on July 18th of 2017, they issued a probation warrant for your arrest. They've also confirmed that warrant within the last 24 hours, stating that it is valid and they want to extradite. So you have a choice today. You have extradition rights. I don't know if you've ever been through this before.
Yeah, I've been through it before.
I figured. Then did they not come get you?
But I just go take care of it.
Okay. You just have a basic choice today?
I read that thing, and I do have a little traffic violation over here.
Okay, so let me tell you what your basic choice is.
Okay.
You can choose today, this is just today, you can choose to waive extradition and agree to go back, or not, and not waive. If you don't waive, you keep all of your rights. Those rights include the right to have an extradition hearing within 90 days, that's here in Arizona, before Louisiana could take you back. You have the right to insist that a governor's warrant signed by the governors of each state be presented in the Arizona court as part of the extradition proceedings. That's why they get 90 days, because they literally need 2 governors' signatures. And then you also have the right to hire a lawyer to represent you in the extradition proceedings. But we don't appoint them because extradition is a civil court case, not a criminal court case. The criminal court case is back in Louisiana.
I've never been in this kind of situation before.
Let me just clarify one more thing, which is that when you've already been convicted in the case, by law, I cannot give you bond no matter what you decide.
I understand that part.
Okay, and so if you want to bypass the whole extradition process and just agree to go back, that would start a 30-day clock once you're done with any Arizona charges or holds. So if you waive, I have to go through your rights and make sure you understand them before you give them up. But if you want to do that, then Louisiana's clock to come and get you, that's the 30-day clock, that will start the day after you are clear of any Arizona charges or holds. And it sounds
Do
like
you know what kind of charges I have?
I can't see that. No, it's got to be in a different court.
Okay.
But you said it's some kind of traffic warrant?
Yeah, I had a traffic warrant, yeah.
And
But it was like.
Is it from Maricopa?
It was in Maricopa, it's like maybe 15
Do you
years ago.
Do you know what city or anything?
No, it was just driving on suspended license.
Officer, do you see any holds on him? Oh.
No.
Well,
Yep.
so I don't know if that is going to hit the sheriff's system during the 30 days or if
Yeah.
it already has or if it's not. I do not know. But it's good that you're aware of it because that means it could. That at some point they could hit the system and then Louisiana's clock would stop. So say on day 28, you're like, oh, they're not coming. And then here comes that traffic warrant and the hold gets put on you at the jail. That stops the clock. You have to take care of the Arizona charge, and then Louisiana's clock starts over at day 1.
Well, I would like to take care of that, and then, I don't know, maybe come back and do my probation over here.
All I can tell you is, because I don't have general authority over the extradition case. We have an extradition judge.
Yeah.
So if you don't waive today, if you keep your rights, you'll be on the 90-day clock, and I will give you a next court date, which will be May 5th at 1:30 in front of the extradition judge. But if you give up your rights, that is going to end the extradition case today because you waived, and then you're just on the 30-day clock. The 30-day clock.
I'll just waive it. I'll take care of it.
All right, then let me ask you if you understand your rights. I have some formal questions, so I always use the script.
Okay.
And then, because I have to ask if you want to give them up. So first I have to make a record that you do know what they are.
Okay.
Pardon me. So first, just to confirm, did you read the waiver of extradition paperwork we gave you? That's the card.
Yes, I did.
All right, do you understand that you do not have to sign that paperwork? Do you understand that? That you don't have to sign a waiver? You have the option of not signing. Do you understand that?
I don't know what to do.
Oh, okay. Well, I can't help you decide. I can just tell you what will happen and the way things go depending on what you decide. But I can't give you legal advice about what's the right decision for you.
Okay.
But if you want to just not do this today, it's fine. I'm going to set you on May 5th. I can't give you bond either way. But if you don't waive today, you'll go to court on May 5th. You'd have another opportunity to waive if you wanted to. But if you waive on May 5th, the clock would start May 6th potentially. I mean, I don't know about your traffic warrant. The traffic warrant could slow things down if it hits the system while you're waiting.
Well, I'll just waive it. It's okay.
Okay, let me go back to this question.
Okay.
Do you understand that you do not have to sign the waiver paperwork?
Yes.
All right, do you understand that you have the right to have an extradition hearing on this Louisiana warrant?
Yes.
Do you understand that you have the right to hire a lawyer at your own expense to represent you in the extradition proceedings?
Yes.
And do you understand that you have the right to insist that a governor's warrant be signed by the governors of both states before you are taken back to Louisiana?
Yes.
All right. So, understanding all those rights, do you want to give them up and sign the paperwork?
Yes.
And do you understand that I have to hold you without bail whether you waive or not?
I understand.
Okay. Has anyone threatened you or promised you anything to get you to sign this paperwork?
No.
And have you had any drugs, alcohol, or medication in the last 24 hours?
No.
All right. Then I find that you knowingly, intelligently, and voluntarily are waiving your right to an extradition hearing in this case and signing the paperwork. My orders will direct our sheriff's office to notify Louisiana that you're ready to return.
Okay.
Louisiana will have 30 calendar days starting tomorrow. Well, I should say starting the day after you're clear of any Arizona charges or holds. So it will start tomorrow, but just not to confuse you too much. But if the warrant that you're talking about or any other Arizona criminal warrant hits the system while you're waiting, Louisiana's clock stops.
Okay.
You have to take care of that here, and then their clock will start again at day 1 once you're clear of the Arizona case. Do you understand that?
Yeah, I understand.
Okay. All right. Understanding all that, you still want to sign the waiver paperwork?
Yep, I understand.
Okay, then I find you knowingly, intelligently, and voluntarily are doing that. And so what I need you to do is, when my clerk is ready, you can step over here. She's going to have you sign, I think, twice. She's going to give you a copy of what you're signing. It is the waiver paperwork. That's why we have to make sure you read it, because you're signing it electronically, and then she's going to give you a copy. Okay?
Okay.
All right, good luck, sir. Just go ahead and sign when she tells you. All right, and then I did receive information prior to court via staff from the sheriff's office that Mr. Jacob Bello and Christine Quinones were both isolated from general population as a potential danger to themselves or others. And so I'm going to go conduct their initial appearances in-house in person immediately after this recording. And I'll advise Christine Quinones, born 7/3/94. She's here on a probation warrant. She's on probation for a Class 6 felony. And I'll let her know there was a petition to revoke her probation filed back on February 10th, and that it alleges she violated terms 3 and 5. I'm appointing a lawyer for her, giving her a court date of May 1st in probation court for a revocation arraignment and possible disposition hearing at 8:30 in the morning in the downtown court. And I'm setting bond in her case. It is my intention to set it at $250 secured with written conditions that I will go over with her, including call her PO within 72 hours of any release. Jacob Lee Bello, or Bello, born 4/8/91, is here on a new case. He got booked in for dangerous drug possession, Class 4 felony, criminal trespassing, Class 6 felony, and resisting arrest, a Class 6 felony. There is probable cause for all of those, and I'm appointing a lawyer for him. I'm setting 3 court dates for him: a status conference May 1st at 8:30 in the morning, a bail eligibility hearing, also known as evidentiary hearing, on May 2nd, 1:30 in the afternoon, and a preliminary hearing May 5th at 8:30 in the same court in downtown Phoenix. And pursuant to law, the court is ordering that he be held without bond in this case because he was out on release. In CR 2024-148-477, his initial appearance in that felony case was October 10 of last year, and it remains open and pending with the next court date 5 days from now. So he is not bailable in this case now. I'll try to explain that to him when I see him. If anything changes after I conduct these initial appearances back in the cell block, my final written order will reflect the court's ultimate decision. It is not the court's intention to update this recording. My final order will reflect what happened. All right, then the court is going to stand in recess until 2 p.m. this afternoon.
Commissioner,
Yes, ma'am.
he waived his rights, correct?
Did it not go through? Okay, hang on, let me log back in. Okay, let's see. This is Mr. Benali.
Did you want me to remove those?
Jeez. Yeah, dang it. Yes, he did waive. I swear it looked right when I hit it. Okay. Now we're going to have that problem where I don't know if the signatures are both going to go on one page. Let's try it.
Okay.
So one of us may have to sign manually is all we got to do, and then we scan it in. Yeah, because extraditions needs one piece of paper with both signatures, so if it won't produce it, we just need to use our pens and scan it in.
Go ahead and sign it again.
Yeah, I'll wait here and make sure that it goes through.
And then 13, can you change it to OPD?
Yes. There we go. Oh yeah, that's one you even told me about. I just missed it. Okay. All right, then I think we're good to go, and we're going to be in recess. So you take that. Okay, thank you.
All rise.
Folks, have a seat. All right, good afternoon. I'm Commissioner Procco. This is the 2 p.m. initial appearance calendar for April 25th, 2025. Court's orders for the taking of fingerprints and DNA that were given on the first calendar of this month shall apply to all matters on this calendar as well. All right, when you hear your name, please step up to the podium that's in the center of the courtroom in here. At the end of your hearing today, you're going to be provided with paperwork, and that will cover everything we go over in here. So that includes your next court dates as well as all of your release conditions. For those of you who will be out of custody prior to your next court date, I do recommend contacting the court you are going to in advance so you can verify your hearing details. Please keep in mind you do have the right to remain silent. Everything you say in the courtroom is being recorded, both audio and video, and could be used in a future court proceeding. We're going to begin today with John James. Sir, if you could step in the courtroom. After that, it's going to be Leticia White. Hi, Mr. James, if you could state your full name and date of birth, sir.
John James, 10/13/1976.
All right, thank you, sir. So you are here for a new case out of Superior Court. It is alleging 1 count of aggravated assault, a Class 3 felony. Now, in this matter, the Public Defender's Office has been appointed. You do have a status conference set on May 1st with a preliminary hearing May 5th, both at 8:30. Those are going to be at the Superior Court located in downtown Phoenix. I did take a look at your history prior to this matter, which does include a prior aggravated assault conviction. I've also taken into account the nature of the offense that you're here for, as well as the level of injuries to this particular victim. Based on that, I do believe a bond is appropriate in your matter. You do have a $250,000 secured appearance bond. If you do post that bond and you are released from custody, it would be subject to the supervision of pretrial services with electronic monitoring to be added prior to your release. You're also ordered not to have any contact whatsoever with the alleged victim in this matter or any complainant or witness. You're not to possess any weapons while on release. This information will be provided to you here in a moment, but do you have any questions regarding any of it?
No.
All right, sir, if you want to go ahead and step over, you can go ahead and have a seat at this time. Looks like your paperwork's set to go there as well. All right, so we've got Ms. White. Elizabeth Shrum is going to be up next.
Good afternoon.
Yeah, right behind the podium there. Hi, ma'am, if you could state your full name and date of birth.
Leticia White, November 7, 1992.
All right, thank you, ma'am. So you are here for a new case out of the Maricopa County Superior Court. The charges here are going to be 4 counts of theft as a Class 3 felony and 5 counts of organized retail theft, Class 4 felonies. You do have some different dates of offense here, April 8, April 9, and April 11. So in this matter, the Public Defender's Office has been appointed here to represent you. You do have a status conference set May 1st with a preliminary hearing May 5th. Those are both going to be at 8:30 a.m. They are located at the Superior Court located in downtown Phoenix. Based on a review of your history, which does include some prior history, specifically out-of-state history, as well as the nature of the offense that you're here for, including the multiple dates of offense and the amount of money involved in the thefts alleged in this matter, you do have a bond. That is a $25,000 cash-only appearance bond. If you do post bond and are released from custody, it would be subject to the supervision of pretrial services with electronic monitoring to be added as part of those release conditions. Your instructions here, your orders, do include the orders that you are not to return to the scene of the offense, you are not to go have any contact with any alleged victim, complainant, witness, or co-defendant, and you're not to possess any weapons since you do have some felony priors in here. So that information I just went through will be included in the paperwork, but do you have any questions regarding anything I've just gone through?
You said it's a cash bond?
That is a cash bond, correct.
So I can't use the bail bondman?
So you can contact a bail bonding company and see if they'll work with you with a cash bond, but you're correct, it is different than a secured appearance bond, which is the standard one that they work with.
Okay.
Okay.
All right, thank you.
All right, thank you. All right, so we've got Elizabeth Shrum and then Damian Stewart's going to be up next. All right, ma'am, your full name and date of birth.
Liz Shrum, August 9th, 1958.
All right, thank you, ma'am. So you are here for an out-of-county warrant. It's for a warrant that was issued out of the Yavapai County Superior Court. They were notified, did both indicate that that warrant was valid and was extraditable. So in this matter, you now have an arraignment hearing set at the Yavapai County Superior Court on April 30 at 8:30 a.m. This is a bondable warrant, even though it's a probation violation warrant. So you do have a bond that's a $25,000 secured appearance bond. So that is the amount you'd have to post in order to be released prior to that court date out in Yavapai County. If you're unable to post the bond, you would remain in custody. Yavapai needs to come and transport you out there in order to attend that court date.
Okay.
All right, any questions regarding that?
No.
All right, ma'am, if you want to go ahead and step over, it looks like your paperwork's set there too.
Thank you.
All right, so we have Damian Stewart. After that, we've got Richard Marks. All right, sir, your full name and date of birth.
Damian Duante Stewart, 12/18/05.
All right, thank you. So you are here for a new case out of the Maricopa County Superior Court. The charge that's been submitted today is one count of aggravated assault, which is a Class 3 felony. So in this matter, the Public Defender's Office has been appointed here to represent you. A status conference is set May 1st, preliminary hearing May 5th, both at 8:30. That's going to be at the Superior Court in downtown Phoenix. I do recognize you don't have any other prior criminal history, although you're only 19, so I would hope that to be the case, but it isn't always. But in light of the nature of the offense that you're here for, which does involve the alleged use of a dangerous instrument during the course of an assault, you do have a bond in this matter. That's a $10,000 secured appearance bond. Now, if you were to post bond and be released from custody, it would be subject to the supervision of pretrial services, and you would have electronic monitoring added prior to your release from this facility. That is being put in place because you're going to have orders here that you are not to return to the scene of the offense. You are not to have any contact with any alleged victim, complainant, or witness, which does mean if you were previously residing at that location, it's my understanding that is the case, you would need to find an alternate residence and provide that information to pretrial services as to where you're going to be residing in the interim, okay? If you need to go back because you have personal items there that you need to obtain, you can only do that in person using a civil standby. That's done by contacting local law enforcement and scheduling it through them. All right, do you have any questions regarding any of that information?
Yes. My name is on the lease, the other person's name isn't.
I'll let you know what my order specifically says.
Okay.
You may not reside at the same location as any alleged victim, even if you are an owner or renter of the residence. So even if your name's on the lease and the other person's name is not, it doesn't matter. You are ordered not to return to that location. You cannot go back there as long as the alleged victim in this matter does reside at that location. Okay?
Okay.
All right. If you want to go ahead and take that paperwork, you can go and have a seat at this time. Thank you. All right, so we've got Richard Marks and John Escalante is going to be up next. All right, Mr. Marks, go and state your full name and date of birth.
Richard Marks, January 14, 1978.
All right, thank you, sir. So you are here for a new case out of the Maricopa County Superior Court. The charge that you have here is one count of aggravated harassment involving an order of protection, which is a Class 5 felony. So in this matter, the Public Defender's Office has been appointed. You have a status conference set May 1st with a preliminary hearing May 5th, both at 8:30. And those will take place at the Superior Court located in downtown Phoenix. Based on a review of your prior criminal history, I have taken into account the date of offense on some of those, but also taken into account your repeated failures to comply with the court order, that being the order of protection issued in this matter. You do have a bond in this case. That is a $5,000 secured appearance bond. If you post bond and are released from custody, it would also be subject to the supervision of pretrial services. You'd also have electronic monitoring added as part of those release conditions.
Excuse me,
You
Your
still have
Honor.
the terms that you are not to return to the scene of the offense. You are not to have any contact whatsoever with the alleged victim in this matter or any complainant or witness. As long as that order of protection is still in place and in effect, you must obey the terms of that order. Your paperwork will be made available to you. You can go ahead and have a seat at this
Excuse me,
time.
Your Honor. I was wondering, how is it aggravated? Why is it
It is aggravated harassment since it involves the charge of harassment and there is an order of protection involved. So you can certainly speak with the attorney that's been appointed to represent you regarding the specific charge that's been lodged against you.
Okay, but there was no harassment.
All right, so let's go ahead and have John Escalante step in. After that, we've got Jason Cavazos. All right, sir, your full name and date of birth.
John Escalante, 6/16/2001.
All right, sir, you've got 3 separate matters here today. So the first 2 that I have here are your 2 probation violation warrants that were issued. In each of your probation matters, you had a petition to revoke filed alleging a violation of terms 3, 6, 7, 11, and 14 of your probation terms. The public defender's been appointed. You have a revocation arraignment hearing set on May 2nd at 8:30. That's going to be at the Superior Court located in downtown Phoenix. In this case, the bonds in each of those warrants has been affirmed. Each of those has a $50 secured appearance bond. In both of those matters, if you do postpone and are released from custody, you are still on supervised probation. You do still need to abide by all terms. That does include contacting probation within 72 hours if you're released from any facility. Your next matter you have here is the new case you were just brought in on. This is for a new case that'll be out of Superior Court. The charges there are 1 count of possession of narcotic drugs for sale. That's a Class 2 felony. 1 count of possession of drug paraphernalia, Class 6 felony. So in that case, the public defender's been appointed as well. The court dates you have here are a status conference May 1 with the preliminary hearing May 5th, both at 8:30. Those will take place at the Superior Court in downtown Phoenix. In that matter, because you already had the warrants outstanding for your probation violation matters and given your history and the nature of the offense, specifically the sales allegation, you do have a bond that's a $5,000 cash-only appearance bond. If you postpone and are released from custody, you are still on supervised probation. So again, you still need to contact probation within 72 hours. You're also ordered not to have any contact with any complainant witness, and you're not to possess any weapons since you have felony priors. That information will be included in the paperwork that you'll be receiving. All right, if you want to step over to your left over there, you can go ahead and have a seat at this time. All right, Mr. Cuevos. After that, we've got Jose Hernandez. All right, sir, your full name and date of birth.
Jason Bradley Cavazos, July 27th, 1980.
All right, thank you, sir. You are here for a new case out of Superior Court here in Maricopa County. In that matter, the charges are 1 count of aggravated assault, that's a Class 6 felony, and 1 count of false reporting, a Class 1 misdemeanor, 1 count of disorderly conduct, that's a Class 1 misdemeanor as well. So in this matter, the public defender's office has been appointed. You do have a status conference set on May 1st with the preliminary hearing May 5th, both at 8:30, and that's going to be at the Superior Court in downtown Phoenix. Based specifically on the nature of the offense that you have here, which include the assault of a healthcare worker, as well as your attempts to evade capture in this matter, you do have a bond, which is a $1,500 secured appearance bond. You also have orders that you are not to have contact with any alleged victim, complainant, or witness involved in this matter.
But it says that I have priors? I've never...
Say that again?
It says that I have priors?
No, I didn't say you have any priors.
Oh,
I can let you know if I'm showing any.
Okay. I don't have any, I've never been to...
No, I only show a misdemeanor.
A misdemeanor here in Arizona?
No, from California.
Oh.
That's the only thing I'm showing up here, but I didn't say that I was basing your release conditions on prior. That's why I'm lowering your release conditions, because I did take into account your otherwise lack of any significant history. So it's really the nature of the offense that you're here for, primarily that aggravated assault charge.
I didn't touch, I mean, I moved because I smelled smoke.
And I'll just warn you not to say anything on record. You have been appointed an attorney to represent you, so you can certainly speak with your attorney. I'll let you know I did base the decision based on the probable cause statement submitted to the court, which did provide some pretty good probable cause. So I did not have any doubts as to probable cause in your matter. Okay? All right, but you can certainly speak with your attorney about any defenses you believe apply in your case.
Okay.
All right, if you want to go ahead and step over, you can go ahead and have a seat. Thank you. All right, so we've got Jose Hernandez. After that, Derek Filer. All right, Mr. Hernandez, go and state your full name and date of birth.
Jose Hernandez, 11084.
All right, thank you. So you are here for 4 separate matters today. So the first matter that I have here is going to be the new case you were just brought in on, which is going to be for a new charge in Superior Court. The counts submitted are 1 count of possession of narcotic drugs, a Class 4 felony, and 1 count of possession of drug paraphernalia, which is a Class 6 felony. So in this matter, the Public Defender's Office has been appointed. The status conference is set on May 1st with the preliminary hearing May 5th, both at 8:30. Those will be at the Superior Court in downtown Phoenix. In this case, based on otherwise your history primarily, because you're currently on probation in 3 separate matters, you do have a bond in this case that's a $500 secured appearance bond. Now, you're still going to be on supervised probation, so even if you postpone in this matter, you are still going to be subject to the supervision of your probation officer and have to abide by the terms of probation. Now, all 3 of your probation matters have also been added to the calendar here today, and that's for Term 1 violations issued in each one of them. So it's the new offense. That's what's triggering those. So in each of those matters, the public defender has been appointed as well. Revocation arraignment hearing set on May 2nd at 8:30. I did read your probation notes. I do understand that you were trying to make some efforts to engage in treatment. You also stayed in contact with your probation officer. That's why I'm just going to do placeholder bonds in each of those cases. Those each have a $50 secured appearance bond. So it ends up being $650 total for all 4 matters. Okay? So you're going to get paperwork for each case. You'll actually get 4 sets since you have 4 different cases here. But do you have any questions regarding these?
So are all of them going to be put together, or?
So at this time, you've got 2 separate court dates. The new felony charge is going to be separate from those probation cases.
Okay.
Assuming they all keep moving forward after those first dates, they do end up usually getting combined together. In other words, they'll be heard on the same date. So it's not like the case numbers get combined. It's just that they get heard together so that they can be hopefully handled all together.
And am I going to be released today, or?
So you do have a bond, so you've got $650 for your bond for the 4 matters. So that is the amount that you would have to post to be released. Now, I'll also note it looks like you might have a hold out of the Mesa Municipal Court. I don't know if that's correct. My notes are just in here from PSA review. So if that is the case, though, if you do in fact have a warrant out of Mesa, did you show that? They've got a hold for you. So even if you post this bond, you're still going to have to see the Mesa judge. That's a completely separate court, okay?
Okay.
All right. Any other questions?
No.
All right, sir. Thank you. All right, so we've got Derek Seiler and then Jonathan Jackson up after that. All right, sir, your full name and date of birth.
Derek Seiler, 1887.
All right, thank you, sir. So you're here for a warrant that was issued out of the Buckeye Municipal Court. That's in their case number CM 2022-958. So in that matter, they've set an arraignment hearing for you on April 30 at 1 p.m. That'll take place at the Buckeye Municipal Court. The address will be included in your paperwork. I did take a look at our docket. It looks like this is now the 2nd warrant issued in this matter. I do know that they've also now filed a separate count against you for your failure to appear in this matter. So for that reason, you do have a bond. The bond in the warrant's been affirmed. That's a $500 secured appearance bond. Since I did set the bond that was in your warrant, I've also appointed counsel to represent you for that issue, for the bond issue. That's required by Rule 6.1 of the Arizona Rules of Criminal Procedure. Do you have any questions regarding this case? All right. Thank you, sir. All right. Jonathan Jackson. After that, it's going to be Bruce Gelbert. Hi, Mr. Jackson. Go ahead and take off your hoodie, and then if you can state your full name and your date of birth, sir. Your full name and your date of birth.
Jonathan Jackson.
Is your date of birth April 14 of 2002?
Yeah.
All right, so you're here for a new case out of the University Lakes Justice Court. The charges here are going to be 1 count of criminal trespass, a Class 2 misdemeanor, 1 count of false reporting to law enforcement, that's a Class 1 misdemeanor, 1 count of shoplifting, also a Class 1 misdemeanor, 1 count of obstruction, which is a Class 2 misdemeanor. So in this matter, the Public Defender's Office has been appointed. You do have an arraignment hearing set on April 30 at 8:30. That's going to be at the University Lakes Justice Court. As you provided your correct information when you were first approached and not waited for them to ID you using fingerprints instead of providing false names repeatedly, you probably would have been released here at this time. But given that that's not the case, that's not what happened here today, according to your probable cause statement, you do have a bond. That's a $500 secured appearance bond. You also have orders not to have any contact with any alleged victim, complainant, or witness, and not to return to where this occurred since you'd already been trespassed from that location. So you'll get that information here in a moment, but do you have any questions regarding it? All right, if you want to go ahead and have a seat, we'll get your paperwork out to you. We've got Bruce Gelbert and Michael Rojas will be up next.
podium, sir.
All right, sir, if you could state your full name and date of birth.
My name is Bruce Talbot, and date of birth is 10/4/67.
All right, thank you, sir. So you're here for a new case out of Superior Court. The charges are 1 count of possession of dangerous drugs, which is a Class 4 felony, and 2 counts of shoplifting. Those are both Class 1 misdemeanors. So for this matter, the Public Defender's Office has been appointed. You do have a status conference set May 1st with a preliminary hearing May 5th, both at 8:30. And those are going to be at the Superior Court located in downtown Phoenix. Based on a review of your history, and you've got a number of prior felony convictions. That's primarily the reason you're going to have a bond today, but that is a $500 secured appearance bond, with the additional orders that you are not to return to the scene of the offense or have any contact with any complainant or witness. Do you have any questions regarding that?
No.
All right. You want to go and step over? You can go ahead and have a seat. All right, so we have Michael Rojas, and then Shawnee Stewart will be up after that. All right, sir, your full name and date of birth.
Michael Rojas, 12/25/90.
All right, thank you. You've been brought in today for a probation violation warrant that was issued. That's for a petition to revoke that was filed in your probation matter. It alleges a violation of terms 3, 4, and 5 of your probation terms. The Public Defender's Office has been appointed. You do have a revocation arraignment hearing set on May 2nd at 8:30. That's going to be at the Superior Court in downtown Phoenix. In this matter, the bond in your warrant's been affirmed. This is a $350 secured appearance bond. If you do post that bond and you are released from custody, you're still on supervised probation. You do still need to abide by those terms, including contacting them within 72 hours. All right, you can go ahead and have a seat. All right, so we've got Ms. Stewart, and then Cecilia Arvizo is going to be up after that. Hi, ma'am, your full name and date of birth?
Shawnee Stewart, 9/17/95.
All right, thank you. You are here for a warrant that was issued for your probation matter, and this is going to be for a petition to revoke that was filed back in February. It alleges a violation of terms 3 and 5 of your probation term. So the public defender has been appointed. You do have a revocation arraignment hearing set on May 2nd at 8:30, and in this case, the bond in your warrant's been affirmed. That's a $150 secured appearance bond. If you post bond and are released from custody, you are still on supervised probation, so you do still need to abide by your terms, including contacting them within 72 hours.
Okay, ma'am.
Do you have any questions regarding that?
So my bond's only 150?
That's correct.
Okay.
Yeah, so if you post that, assuming you have no other holds, you would be released.
Thank you so much, ma'am.
Okay? All right, so we've got Ms. Arvizo. After that, Gerardo Santana. Ma'am, your full name and date of birth?
It's Cecilia Arvizo, 2/10/89.
All right, you are here for a new case out of Superior Court. This is alleging 1 count of theft of a means of transportation, which is a Class 3 felony. The Public Defender's Office has been appointed to represent you. You have a status conference set on May 9 with a preliminary hearing May 13, both at 8:30. That's going to be at the Superior Court in downtown Phoenix. I did review your history, which I believe was limited to just some misdemeanor matters, as well as the victim impact statement reviewed in the case and the nature of the offense that you're here for. So based on that, I am going to be releasing you here today, but it is going to be subject to the supervision of pretrial services. You are going to have electronic monitoring added as part of those release conditions. They are going to include the terms that you are not to return to the scene of the offense. You cannot go back to that complex. You are not to have any contact with any alleged victim, complainant, or witness in this matter. You cannot have contact with the victim, period. And I'll just warn you that a violation of a no victim contact order in a criminal release order could constitute aggravated harassment. That's a Class 6 felony. If you come in on a new felony offense while being on felony release, you would be non-bailable at that point, okay? Do you have any questions regarding that?
No.
All right, if you want to go and step over, looks like your paperwork's set to go over here. You can have a seat.
Thank you, Your Honor.
All right, so we've got Gerardo Santana. After that, it's going to be Maria Patino. All right, sir, your full name and date of birth?
Gerardo Galeano Santana, 3/31/95.
All right, so you're here for 2 separate cases. So I'm going to start with the warrant that you have out of the Tolleson Municipal Court. Their case number is CM 2019-0194. In that matter, an arraignment hearing's been set on May 12th at 8:30 a.m. That'll be at the Tolleson Municipal Court.
Okay.
This is a post-adjudication warrant issued in that matter. Because it is a post-adjudication warrant issued, I am going to be releasing you to appear at that next court date on your own. You are going to be released on your own recognizance, which is your promise to appear.
Okay.
You do have a second case here, which is going to be for a warrant issued out of the Superior Court here for a direct complaint that's been filed. And that alleges 1 count of aggravated domestic violence, a Class 5 felony, and 1 count of assault, a Class 1 misdemeanor. The date of offense for that is October 27 of 2019. So in this matter, the Public Defender's Office has been appointed. You do have a status conference set May 9 with the preliminary hearing May 13, both at 8:30, and that'll be at the Superior Court in downtown Phoenix. I don't show you received notice of the summons that went out since I show that it was sent back return mail. For that reason, and because the date of offense is back in 2019, I am going to be releasing you today. It is going to be subject to the supervision of pretrial services with electronic monitoring added. You are going to have terms here that you're still not to have contact with the alleged victim in this matter or any complainant or witness in this case. Okay? Do you have any questions regarding that?
No.
All right. If you want to go and step over, you can go
Just
and pick up
about
the
the
paperwork.
ankle monitoring. Where do I go?
They'll let you know.
Okay.
Yeah, they'll let you know. All right. So we've got Maria Patino and then Devin Nolan will be in the up after that. All right, ma'am, your full name and date of birth?
Maria Patino, May 6, 2000.
All right, thank you. You are here for a new case out of the Goodyear Municipal Court. The charge here is 1 count of criminal trespass in the 3rd degree, which is a Class 3 misdemeanor. So in this matter, you're not entitled to court-appointed counsel due to the nature of the charge, since it is a misdemeanor offense that doesn't otherwise qualify. But you do have the right to retain an attorney on your own behalf to represent you in this matter. You have a court date currently set on arraignment hearing on May 14 at 1 p.m. That'll be at the Goodyear Municipal Court. The address for that court is going to be provided in your paperwork. In this matter, you are being released on your own recognizance. It is going to be your promise to appear at future court dates. You're also going to be ordered not to return to the scene of the offense, not have any contact with any alleged victim, complainant, or witness involved in this matter. So you cannot return to that location. Do you have any questions regarding that?
No.
All right, if you want to go and step over, you can go and pick up that paperwork that's over there. All right, we have Devin, Nolan, and Francisco Gill is going to be up after that. All right, Mr. Nolan, go and state your full name and date of birth.
Davon Nolan, September 19, 2002.
All right, thank you, sir. All right, so you are here for a new case out of the El Mirage Municipal Court.
Correct.
So in that matter, the charges are 3 counts of criminal damage and 1 count of disorderly conduct. Those are Class 1 misdemeanors. So in that matter, you are entitled to court-appointed counsel because it is considered to be a domestic violence offense in nature, but that will be handled by the El Mirage Municipal Court. So they'll address that at your next court date. That's going to be an arraignment hearing on May 13 at 8 a.m. at the El Mirage Municipal Court, the address for which will be included in your paperwork. Based on a review of your history, or otherwise I think really lack thereof, I don't think you had any criminal history, you are going to be released here today on your own recognizance. It is your promise to appear. But you do have additional terms given the nature of the offense. That's that you can't return to the scene of the offense, you can't have any contact with any alleged victim, complainant, or witness in this matter. So if you were previously residing there, which it's my understanding you were, you would need to find an alternate residence, at least until further court order.
Okay.
If you need to return to the home in person because you have personal items there that need to be gathered, you can only do that in person using a civil standby. That's not by contacting local law enforcement. Okay?
What is a civil standby by chance?
What is a civil standby?
Yes, ma'am.
So what that means is law enforcement stands by while you go into the house because you have a court order saying you can't go back in there.
Right.
This is that exception where if you contact local law enforcement and schedule it through them, they can accompany you to that location to make sure nothing happens, everything's fine, but you at least get to get your personal items.
Okay,
That's what it is.
Gotcha.
Okay? All right, any other questions?
No, ma'am.
All right, do you want to step over and go and pick up that paperwork there? All right, we have Francisco Gill. After that, Justin Gully. All right, sir, your full name and date of birth.
Francisco Gill, May 11th, 87.
All right, thank you, sir. So you are here for 2 separate cases today. I'll start with your Superior Court matter. This is for new charges that have been submitted there. That's for 1 count of DUI. That's a Class 1 misdemeanor. That's the only count I was able to find probable cause on. They did submit an additional count of possession of dangerous drugs that I was not able to find probable cause on. It doesn't necessarily mean it's going away, but they did not give me sufficient information. So the Public Defender's Office has been appointed. You do have a status conference set May 9 with the preliminary hearing May 13, both at 8:30 at the Superior Court in downtown Phoenix. And in this matter, I did review your probation note since you're currently on probation. That's the other case we have here. And I did see that you were in contact with probation because you have maintained that contact at least. I am going to release you to appear at that next court date on your own. So you are going to be released subject to the supervision of your probation officer. You do need to contact probation within 72 hours of your release. So your next case that you have here is the probation matter, which is now here for a Term 1 violation. So for that term 1, the public defender's been appointed as well. Revocation arraignment hearing set May 2nd at 8:30, and you have the same release conditions there. You're being released on your own recognizance, subject to probation supervision.
Okay.
So just keep in mind, I just gave you 2 different sets of court dates there. The probation matter is the one coming up first on May 2nd.
Mm-hmm.
Okay? Do you have any questions regarding that?
No, ma'am.
All right, if you want to go ahead and step over, we'll get you your paperwork here in a moment, but you can go ahead and have a seat. All right, we have Justin Gully, and then Olga Chandler will be up next. All right, sir, your full name and date of birth.
Justin Gully, August 21st, 1993.
All right, thank you, sir. You are here for a warrant that was issued out of the West Mesa Justice Court in JC 2024-111264. So in that case, you now have a arraignment hearing set on May 13 at 8:30. That'll be at the West Mesa Justice Court. The address will be included here for you still. I did take a look at your docket. Looks like this is the first warrant issued. Since this is a drug paraphernalia case and the first warrant issued in this matter, I'm going to give you a second shot to appear at that next court date. You are being released on your own recognizance. That is going to be your promise to appear. So I'll just warn you, if you fail to appear on May 13, it's likely another warrant's going to issue at that time. Might not have the same luck next time you come through. Okay?
Right.
Any questions regarding that?
Nope.
All right, if you want to go and step over, you can go ahead and have a seat. All right, so we've got Ms. Chandler. Ramon Vallejo will be up next. All right, ma'am, your full name and date of birth.
Olga Victoria Chandler, 62373.
All right, thank you. So you are here for a new case out of the Buckeye Municipal Court. The charges here are going to be 1 count of disorderly conduct, 1 count of assault, both Class 1 misdemeanors. So in this matter, because it is considered to be a domestic violence offense in nature, you are entitled to court-appointed counsel, but that will be handled by the Buckeye Municipal Court. So they'll address that appointment at your next court date, which is going to be an arraignment hearing May 13 at 2 p.m. The address for that court will be included in your paperwork. In this matter, based on your otherwise lack of any other criminal history that I could find, you are going to be released on your own recognizance. It is going to be your promise to appear, but given the nature of the offense here, you do have the terms that you are not to return to the scene of the offense or have any contact with any alleged victim, complainant, or witness in this matter, which does mean if you were previously residing there, you would need to find an alternate residence, at least until further court order. If you do need to return in person because you have personal items there that need to be gathered, you can only do so in person using a civil standby, which is done by contacting local law enforcement.
Okay.
Okay. Do you have any questions regarding that?
Yeah, one, is it just my mom that it shows the domestic violence on, or is my sister included in it?
I think it might be both of them.
Okay.
I'll double check for you. Okay, no, your sister's not listed. She's only listed as a reporting party. Keep in mind, though, that since she is technically considered to be a witness to it, she still falls within that.
Okay.
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 All right. All right.
Thank you.
All right, so we've got Mr. Vallejo, and then Damian Rosales is going to be up next. All right, so your full name and date of birth?
Ramon Vallejo, 011603.
All right, so you're here for a warrant issued out of the Goodyear Municipal Court. That's in their case number TR 2024-01242. In that matter, an arraignment hearing is set on May 14. That's going to be at 1 p.m. at the Goodyear Municipal Court. This is a post-adjudication failure to pay warrant. In other words, they're saying you have a fine there that was not taken care of, which is why the warrant's been issued.
That was a ticket fine.
So I am going to release you on your own recognizance to appear at that next court date, since it is a post-adjudication warrant. So you just need to make sure you show up on May 14th to take care of it, or another warrant could issue. Okay?
Thank you.
All right, if you want to go ahead and step over, you can go ahead and pick up that paperwork there. We've got Mr. Rosales, and after that it'll be Martin Rowan.
Rosales.
All right, so your full name and date of birth?
Damian Rosales, 6804.
All right, so you've got 3 separate cases here today. I'm going to start with the warrant issued out of the El Mirage Municipal Court. This is an initial arrest warrant that was issued. It's not a failure to appear warrant. It's a warrant that was issued in lieu of a summons. The charge here is 1 count of possession of drug paraphernalia, which is a Class 1 misdemeanor with the offense date of February 25th of 2025. So in that matter, you're not entitled to court-appointed counsel due to the nature of the offense, but you do have the right to retain an attorney on your own behalf to represent you in this case. You do have an arraignment hearing set on May 13 at 8 a.m. That's going to take place at the El Mirage Municipal Court. And in this matter, since it is an initial arrest warrant, I am going to be releasing you on your own recognizance, which is going to be your promise to appear. You do have two other cases here, which are going to be your probation matters. The reason they were added is for Term 1 violations. It does appear as though they were added based on this other offense, that drug paraphernalia case. Okay, so it's a Term 1 based on that matter. So in this case, give me 1 second here because I see your notes are up here now. They weren't earlier. All right, so in both of your matters, the Public Defender's Office has been appointed. A revocation arraignment hearing is set May 2nd at 8:30 a.m. That's going to be at the Superior Court in downtown Phoenix. And in each of those matters, I am going to be releasing you today on your own recognizance, but you are still subject to the supervision of your probation officer. So you do need to contact probation within 72 hours of your release and otherwise comply with the rest of your terms. Looks like you haven't been around what they've attempted prior residence calls. So you need to make sure you're complying with probation now because they can file a supplemental petition to revoke, and at that point, you're not going to have the same outcome. They're not going to release you, okay? Do you have any questions regarding that?
Yeah.
All right, if you want to go ahead and step over, you can go ahead and pick up that paperwork there. All right. All right, give me just 1 moment here. Katrina, this one has to be no PC. I didn't hear anything.
I'm sorry?
This one will be a no PCM, but I'm going to enter that all in right now.
Okay.
Yeah, give me 1 minute. I have to do your paperwork here, so it's going to take me a second to catch up, just so you're not standing there. Okay, those have all been signed. All right, Mr. Ron, go ahead and step in again. All right, so your full name and date of birth?
Martin Ruan Jr., August 28th, 1986.
All right, sir. So you've got three separate matters here today. I'll go ahead and start with the new case that just came in. This is for a new case out of Superior Court. The charges submitted there are 1 count of possession of dangerous drugs for sale, which is a Class 2 felony, and 1 count of possession of dangerous drugs, which is actually a Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony. I was not able to find probable cause on the charges that were submitted to the court here today. What that means for you is it doesn't mean the case is going away. I was not provided with sufficient information to proceed, but I am still going to be appointing an attorney to represent you in this matter. We are still going to be setting some court dates for you. That's a status conference May 9 with a preliminary hearing May 13, both at 8:30. Those will be at the Superior Court in downtown Phoenix. But because I was unable to find probable cause here today, I'm unable to set any release conditions. So you are being released without any conditions being imposed in this matter. You do have 2 other matters here, and that is your probation cases, and they are here for a alleged Term 1 violation. So that Term 1 violation is related to the offense that I just found no probable cause on. As a result of that, I can't find probable cause for the Term 1 either. So it's going to be the same thing here, where I'm going to be appointing counsel to represent you. You're going to have a revocation arraignment hearing still set on May 2nd at 8:30. And in this matter, because I was not able to find probable cause, I cannot set release conditions in those cases as well. So just keep in mind, you do still have court dates here. I do always recommend contacting the court in advance so you can verify your hearing details, because if those charges do end up going forward, because they can still file on these, and you fail to appear at your court date that you've been advised of here today, a bench warrant could issue for your arrest, okay? Do you have any questions regarding that?
So you're releasing me?
You're being released in these matters because I can't set release conditions. So you're being released without any conditions being imposed.
Okay, thank you.
All right, if you want to go and step over, we'll provide you paperwork that provides that information as well. All right, so it looks like we do have Mr. Wilson on the line. Are you able to hear me okay?
Yes, Your Honor.
All right, perfect. I'm going to go ahead and call in our first matter that we have here that does require an interpreter. This is going to be for Yuri Amaya.
Amaya. Yeah, he's on for hearing.
He needs the headphones?
Yeah, he's
Okay. All right, Mr. Wilson, give me 1 moment. It sounds like we need the headphones here, so.
No problem, Your Honor.
And while we're waiting on that, Mr. Wilson, if you could just go ahead and do your appearance, we'll get that done.
No problem, Your Honor. Roberto Wilson, court interpreter.
Yeah, I have to adjust the volume.
If it's too long.
Hi, Mr. Amaya, are you able to hear us using those?
¿Puede escucharnos bien, señora Amaya, utilizando esos audífonos?
Sí.
Yes.
All right, sir, if you could state your full name and your date of birth.
Señor, ¿nos puede dar su nombre completo y fecha de nacimiento, por favor?
Uriel Amaya Robles, 6-3-72.
Uriel Amaya Robles, 6-3-1972.
All right, sir, you are here for a new case out of the Maricopa County Superior Court. There are 3 counts that have been submitted.
Ok, señor, está aquí presente por un nuevo caso del Tribunal Superior de Maricopa. Son 3 acusaciones que tiene en su contra.
1 count of aggravated assault, which is a Class 6 felony, and 1 count of assault, a Class 1 misdemeanor.
Tiene una acusación de agresión con agravantes, que es un delito clase 6, y una acusación de... Sorry, Your Honor, for the interpreter. Could you repeat?
The assault is a Class 1 misdemeanor.
Y agresión, que es una falta clase 1.
And a count of disorderly conduct, which is also a Class 1 misdemeanor.
Y una acusación más de alteración del orden público, que también es una falta clase 1.
The Public Defender's Office has been appointed to represent you in this matter. You currently have 2 court dates set at the Superior Court located in downtown Phoenix.
Se ha asignado a un abogado de la Defensoría Pública para que lo represente y usted ya tiene asignadas 2 audiencias para presentarse en las instalaciones del Tribunal Superior de Maricopa en el centro de Phoenix.
That's a status conference May 1st and a preliminary hearing May 5th, both at 8:30 a.m.
Va a tener una consulta de actualización el 1 de mayo y una audiencia preliminar el día 5 de mayo, ambas audiencias a las 8:30 de la mañana.
Based on the nature of the offense that you're here for, specifically the violent nature of the offense as well as the involvement of a minor, you do have a bond in this matter. That's a $10,000 secured appearance bond.
Debido a las características de las acusaciones en su contra y las acciones violentas en este caso, así como también la cuestión de que estaba presente un menor, tiene una fianza en este caso de $10,000 con garantía.
If you did post bond and were released from custody, it would be subject to the supervision of pretrial services, and you'd also have electronic monitoring added as part of those release conditions.
Si usted puede pagar su fianza y es puesto en libertad, va a estar puesto en libertad bajo los servicios de control de procesados con monitoreo electrónico.
The electronic monitoring is being added because you are going to have orders that you are not to return to the scene of the offense or have any contact with the alleged victim or any witness in this matter.
Se está añadiendo el monitoreo electrónico porque parte de sus medidas cautelares son que no puede regresar al lugar del supuesto ilícito y no puede tener ningún tipo de contacto con ninguna de las supuestas víctimas o de los supuestos testigos.
That does mean you will need to provide an alternate residence to pretrial services because you cannot go back to your own residence at this time.
Eso significa que va a tener que darle una nueva dirección donde pueda ser localizado por parte del Departamento de Control de Procesados, ya que no puede regresar a su domicilio.
If you do need to return there in order to collect any necessary personal items, you can only do that in person using a civil standby. That's done by contacting local law enforcement and scheduling it through them.
Si usted requiere ir a su residencia para recoger algunas pertenencias, tiene que hacerlo a través de una escolta policíaca. Esto es que usted tiene que ponerse en contacto con alguna agencia del orden público para poder programar una cita para que lo acompañen y estén presentes mientras usted recupera o saca sus pertenencias.
Do you have any questions regarding that information?
¿Tendrá una pregunta acerca de la información que le acabo de dar?
No, todo está claro.
No, everything's clear.
All right, thank you, sir.
Ok, muchas gracias.
Just give me 1 second, Your Honor.
You bet. And as soon as we're clear, Mr. Wilson, we'll call our next matter.
No problem, Your Honor.
Yep, we're ready. If we're good to go in there, we're ready.
Yeah.
Yep. All right, Mr. Lemus, come on in.
¿Sí gusta estar, señor Lemus?
Right behind the podium there.
Atrás del podio.
And sir, if you could state your full name and your date of birth.
Señor, ¿nos puede dar su nombre completo y fecha de nacimiento?
Joselino Lemos Fernández, 20 de noviembre de 1987.
Joselino Lemus Fernández, November 20th, 1987.
All right, thank you, sir. You are here for a new case out of the Superior Court here in Maricopa County.
Señor, está aquí usted presente el día de hoy por un caso nuevo del Tribunal Superior del Condado de Maricopa.
This is for 5 counts of sexual conduct involving a minor. Those are Class 2 felonies.
Tiene 5 acusaciones de conducta sexual con un menor, que es delito clase 2.
In this matter, the Public Defender's Office has been appointed to represent you, and you currently have 2 court dates set at the Superior Court located in downtown Phoenix.
Se le ha asignado un abogado de la Defensoría Pública para que lo represente en este caso y ya tiene establecidas 2 audiencias
That's a status. Oh, sorry, go ahead.
en las instalaciones del Tribunal Superior en el centro de Phoenix.
That'll be a status conference May 1st and a preliminary hearing May 5th, both at 8:30 a.m.
Va a ser una consulta de actualización el día 1 de mayo y una audiencia preliminar el día 5 de mayo, ambas a las 8:30 de la mañana.
In this matter, based on the nature of the offense that you're here for, the fact that there are multiple victims and the strength of the evidence in the case, you do have a bond in this matter.
Debido a las características de las acusaciones en su contra y el hecho de que hay múltiples víctimas y alegatos en este caso, se le va a aplicar una fianza.
That is a $250,000 cash-only appearance bond.
Es una fianza de $250,000 en efectivo solamente.
If you do post bond and were released from custody, it would be subject to the supervision of pretrial services with electronic monitoring added prior to your release.
Si usted puede pagar la fianza, sería puesto en libertad bajo los servicios de control de procesados con monitoreo electrónico.
That is being put in place pursuant to Arizona law, but also because you're going to have orders that you are not to have contact with any victim, complainant, or witness involved in this matter.
Esto en base a las leyes del estado de Arizona, pero también a los términos y condiciones de las medidas cautelares que incluyen el que no puede regresar al lugar del supuesto ilícito, no puede tener ningún tipo de contacto con ninguna de las supuestas víctimas, ninguno de los supuestos demandantes y ninguno de los supuestos testigos.
You're also not to have contact with any minors.
Y tampoco puede tener ningún tipo de contacto con menores de edad.
This information will be included in your paperwork, but do you have any questions regarding anything that I've just gone through?
Toda esta información se le va a dar por escrito en los documentos que se le van a dar en un momento, pero ¿tendrá alguna pregunta para mí? No.
All right, sir, if you want to go ahead and step over, you can go ahead and have a seat, or they'll let you know what to do.
Ok, si gusta pasar y tomar un asiento, le van a decir qué es lo que tiene que hacer.
All right, Mr. Wilson, that was our last matter. I appreciate your help today.
No problem. Thank you very much, Your Honor.
All right, thank you. All right, I'll go ahead and put our house calls on record here. The first one is going to be for Lucretia Adair, date of birth 12/16/82, and I show she's house call due to being in medical ISO.
Yes, you are. She's medical ISO.
All right, so she's got her 3 matters here. First 2 are both going to be probation violation warrants that were issued. In each of those cases, there was a petition to revoke filed alleging a violation of terms 3 and 5, and the public defender's been appointed. Revocation arraignment hearing set on May 2nd at 8:30, and the bond in each warrant's been affirmed. Each of those has a $250 secured appearance bond. She's also here on a warrant issued out of the St. John's Justice Court in CR 2017-0119, and that matter and arraignment hearing is set April 30 at 8:30 a.m. at St. John's. And in that matter, she's got a $2,500 secured appearance bond. Counsel has been appointed in that matter pursuant to Rule 6.1. All right, our next matter is going to be for Evander Bass. I show he is a house call due to being combative.
Yes, Your Honor.
All right, so he's here for a new case out of Superior Court. This is alleging 1 count of organized retail theft, a Class 4 felony, 1 count of burglary in the 3rd degree Class 4 felony, 1 count of resisting arrest Class 6 felony. Those are the counts I was able to find probable cause on here today. There are additional counts that I did not find probable cause on. That's 3 counts of organized retail theft, 1 count of resisting arrest, 1 count of possession of drug paraphernalia, and 1 count of criminal trespass involving a railroad. So in this matter, the Public Defender's Office has been appointed. Status conference is set May 9 with the preliminary hearing May 13, both at 8:30. And that'll be at the Superior Court located in downtown Phoenix. And in this matter, primarily based on the strength of the evidence or lack thereof that's been presented to the court, he is being released. That's going to be subject to the supervision of pretrial services with orders not to return to the scene of the offense, not to have any contact with any alleged victim, complainant, or witness, or co-defendant in this matter. He is not to possess any weapons while on release. Aubrey Thomas, date of birth 2/12/1981. I show he is a house call due to being bizarre behavior. All right, so he's here for a new case out of the Surprise Municipal Court. It's alleging 2 counts of criminal trespass in the 3rd degree. Those are both Class 3 misdemeanors. He's not entitled to court-appointed counsel due to the nature of the charge. An arraignment hearing is set May 28 at 1:30 at the Surprise Municipal Court, and he is being released on his own recognizance with orders not to return to the scene of the offense. Losel Menekaha, date of birth 10/11/2004. I show he is a house call due to danger to cells. Is that right?
Yes, Your Honor.
All right, so he's here for an out-of-county warrant. This is out of the Mojave County Superior Court. It is a probation violation warrant. An arraignment hearing is set April 30 at 8:30 at the Mojave County Superior Court. And this is a no-bond warrant pursuant to Rules 27.7 and 7.2 of the Arizona Rules of Criminal Procedure. He is being held without bond at this time. All right, so that is now everybody. I'm going to go ahead and turn off the recorder.
All right.
So you may be seated. This is the time set for the 5 p.m. initial appearance calendar for April 25th, 2024.
Esta es la vista de comparecencia inicial de las 5 de la tarde del 25 de abril del 2025.
The court orders for the taking of fingerprints and DNA samples made on the 1st of this month will apply to all matters on this calendar.
La orden judicial para la toma de huellas dactilares y la muestra de ADN que se emitió el primer día de este mes está vigente para todas las causas.
I am going to be asking you each to come up to the podium one by one.
Voy a pedirles que pasen al podio uno por uno,
Where I will ask you for your first and last name
voy a pedirles que digan su nombre y su apellido,
and your date of birth.
y también su fecha de nacimiento.
I will then advise you as to why you are here,
Después les informaré por qué están aquí,
whether or not an attorney has been appointed to represent you,
y si es que se nombró uno un abogado para que los represente.
what your upcoming court dates will be,
También les informaré cuáles son sus próximas audiencias,
what your bond will be if you are eligible for bond,
también les diré cuál es la fianza que se fijó en su caso si es que se fijó una fianza,
and your release conditions.
y también les informaré sus medidas cautelares.
Some of you may have some questions as I am providing this advisement to you.
Tal vez les surjan preguntas cuando les esté proporcionando este aviso.
I would just request that you hold on to your questions
Les pido que por favor esperen para hacer sus preguntas
until I complete that advisement.
hasta que complete el aviso que tengo que darles.
The first person that I am going to call to the podium
La primera persona a la que le pido que pase al podio es
is Alejandro Rodriguez.
Alejandro Rodríguez.
Mr. Morales, will you please have a seat in the chair?
Señor Morales, por favor, tome asiento en la silla.
Sir, can you please state your first and last name and your date of birth?
Por favor, puede decir su nombre y su fecha de nacimiento.
8279.
8279.
What is your first and last name?
¿Cuál es su nombre y su apellido?
Alejandro Rodríguez.
Alejandro Rodríguez.
You are here today because a warrant was issued for your arrest.
¿Usted está aquí porque se expidió una orden de detención en su contra?
No sé.
I'm sorry, it's
I
not a
know.
warrant. I'm sorry, I do have to correct that.
Perdón, tengo que hacer una corrección.
A direct complaint was filed.
Se presentó una querella directamente.
You were charged with 2 counts of unlawful use of food stamps.
A usted se le presentaron 2 puntos acusatorios de uso ilícito de estampillas de alimentos.
A Class 6 felony.
Delito de categoría 6. I know.
And fraudulent schemes and practices, a Class 5 felony.
Y también por fraude, un delito de categoría 5.
And 1 count of theft, a Class 3 felony.
Y también por robo simple, delito de categoría 3.
The date of these alleged offenses is
¿Dónde dice eso yo?
La fecha en que se cometió estos presuntos ilícitos es
January 2020 through June 2023.
en enero 20 a junio 23.
I did appoint an attorney to represent you in this matter.
¿Nombré a un abogado para que lo represente en este caso?
I'm going to ask that you refrain from speaking while I'm speaking.
I don't know.
Le voy a pedir, señor, que no hable mientras yo estoy hablando.
I am trying to advise you as to what is going on so that you will know what is going on.
Estoy tratando de informarle qué es lo que está ocurriendo para que usted esté al tanto.
But if you're talking while I'm talking, then you can't hear what I'm saying.
Pero si usted habla al momento que yo estoy hablando, entonces usted no puede escuchar lo que estoy diciendo.
You have a status conference hearing on May 2nd at 8:30. You're missing a hearing.
¿Usted tiene una consulta de actualización el 2 de mayo a las 8:30?
We're going to pause for one moment.
Vamos a hacer una pausa.
But you also have to set it for a preliminary hearing.
This one is specific. It's an AG, so it needs to go to ROM.
Thank you. Okay. Then, because you were on felony release at the time that these alleged offenses occurred,
Your Honor, could you please repeat that for interpretation purposes?
because you were on felony release at the time that these alleged offenses occurred,
Como usted estaba en libertad por delito al momento en que ocurrieron estos presuntos ilícitos,
you are not eligible for bond today by statute.
usted no cumple con los requisitos para que se fije una fianza el día de hoy, según lo que indica la ley.
So I did schedule an evidentiary hearing for you
Así que he programado una audiencia probatoria para usted,
for May 2nd at 1:30.
que se llevará a cabo el 2 de mayo a la 1:30.
This completes everything that I needed to advise you of this afternoon.
Con eso que se completa toda la información que tenía que proporcionarle esta tarde.
If you have no questions for me regarding your release conditions,
Si usted no tiene ninguna pregunta que hacerme en relación a sus medidas cautelares,
please step to your left,
por favor pase a la izquierda.
and the officer will give you your paperwork.
El agente le entregará su documentación.
Mr. Morales, will you please come into the courtroom?
Señor Morales, por favor pase a la sala.
Sir, can you please state your first and last name and your date of birth?
Señor, por favor, ¿puede decir su nombre y su apellido y su fecha de nacimiento?
Sí, Armando Veleta Morales, 7 de agosto del 87.
Yes, Armando Veleta Morales, August 7, 87.
Sir, you are here for two matters.
Usted está aquí por dos causas.
You have one new case
Tiene un caso nuevo
and one a warrant out of West McDowell Justice Court.
y una orden de detención que se emitió en el Juzgado de Paz de West McDowell.
On your new case,
En relación al caso nuevo,
you were charged with one count of aggravated DUI.
a usted se le acusa de un punto acusatorio de conducción bajo los efectos de sustancias con agravante.
Driving with a license that has been suspended
Conducir con una licencia que se suspendió
for a previous DUI,
por un DUI previo,
a Class 4 felony.
un delito de categoría 4.
I did find probable cause as to this offense.
Y determino que si hay motivo de procesamiento en lo relacionado a este acto ilícito.
I did appoint an attorney to represent you in this matter.
Y he nombrado un abogado para que lo represente en esta causa.
You will have a status conference hearing on May 1st at 8:30.
Usted tiene una consulta de actualización el 1 de mayo a las 8:30.
And a preliminary hearing on May 5th at 8:30.
Y una audiencia preliminar al 5 de mayo a las 8:30.
You have a secured appearance bond in the amount of $2,500.
Usted tiene una fianza con garantía por una cantidad de $2,500.
If you are able to post bond,
si usted puede pagar la fianza,
you will be released to pretrial services.
Usted quedará en libertad bajo la supervisión de la Agencia del Control de Procesados,
where you will be required to participate in alcohol testing and monitoring.
Donde a usted se le exigirá que participe en monitoreo de alcohol y drogas.
As to your warrant out of West McDowell Justice Court,
y con respecto a la orden de detención del Juzgado de Paz de West McDowell,
a warrant was issued when you failed to appear for your court date.
Se emitió una orden de detención en su contra cuando usted no se presentó a su audiencia.
I did appoint an attorney to represent you in this matter.
He nombrado un abogado para que lo represente en esta causa.
You have an arraignment hearing on April 30th at 8:30.
Usted tiene una vista incuatoria programada para el 30 de abril a las 8:30.
And you have a secured appearance bond in the amount of $500.
Y usted tiene una fianza con garantía por una cantidad de $500.
Your total bond between the two cases,
el total de la fianza en ambos casos,
is a secured appearance bond in the amount of $3,000.
Es una garantía con fianza por un total de $3,000.
Failure to comply with your release conditions,
debe cumplir con sus medidas cautelares,
or failure to appear for your court dates,
si no cumple con las medidas cautelares o no se presenta para las audiencias programadas,
will result in a forfeiture of any bond that you posted.
Si usted no cumple con esto, esto resultaría en que se decomise cualquier fianza que usted pague.
A warrant will issue for your arrest.
Y se emitirá una orden de detención en su contra.
And additional bond could be imposed.
Y se podría imponer una fianza adicional.
This completes my advisement to you.
Con esto completo el aviso que tenía que darle.
If you have no questions for me regarding your release conditions,
si usted no tiene preguntas que quiera hacerme en relación a sus medidas cautelares,
please step to your left.
Por favor, pase al lado izquierdo.
And the officer will give you your paperwork.
Y el agente le entregará su documentación.
Madam Interpreter, can you inquire as to whether anybody else is in need of your assistance before I excuse you?
Happy to do so, Your Honor. ¿Hay alguien más en la sala que necesite la ayuda del intérprete? Levante la mano.
It does not appear that anybody else needs the assistance of the interpreter, so thank you so much for helping us this afternoon. You may be excused.
Thank you, Your Honor. Have a good day.
Mr. Johnson, will you please come into the courtroom?
Mr. Johnson.
Mr. Johnson needs to pull his pants up. And Mr. Meza, if you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
Leroy Johnson, 31078.
You are here today because you have one new case and then you have two warrants for failing to appear for a court date. On your new case, you were charged with one count of possession of drug paraphernalia, a Class 6 felony, and one count of resisting arrest with risk of physical injury, a Class 6 felony. I did find probable cause as to both counts, and I did appoint an attorney to represent you. You will have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. Because you were on felony release at the time that these alleged offenses occurred, you're not eligible for bond today per statute. So I did have to schedule an evidentiary hearing for you for May 2nd at 1:30. Then as to your warrants for failing to appear, an attorney was already appointed to represent you in those matters. You'll have a disposition hearing on May 1st at 8:30 in one matter, and a status hearing on May 1st at 8:30 in the other. You have a secured appearance bond in the amount of $2,500 per warrant. So your total secured appearance bond for the warrant is $5,000. I would caution you against attempting to pay the bond until you find out whether or not you're going to be eligible for bond in the other matter. This concludes my advisement to you. Mr. Mesa, if you'll please come to the courtroom. And Mr. Flanagan, if you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
My name is Fernando Meza, and I was born June 2nd, 2003.
You are here today on two matters. You have one new case, and then you have a warrant out of Pinal County. On your new case, you were charged with one count of possession of a dangerous drug, a Class 4 felony, and one count of unlawful flight from law enforcement, a Class 5 felony. I did not find probable cause for the possession of a dangerous drug, but I did find probable cause as to the unlawful flight from law enforcement. I did appoint an attorney to represent you in this matter. You will have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $2,500. As to your warrant out of Pinal County, I did appoint an attorney to represent you in that matter. You will have an arraignment hearing on April 30th at 8:30. The warrant indicated that you are not eligible for bonds because it's a violation of probation. So I would caution you against attempting to pay bond until you get your Pinal County matter situated. That takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you'll please step to your left, the officer will give you your paperwork. Mr. Flanagan, will you please come into the courtroom? I do understand that we have counsel here for this matter, so Mr. Hendrickson, will you like to state your appearance at this time?
Yes, Your Honor, thank you. This is Troy Hendrickson, the defendant Donald Patrick Flanagan.
Mr. Flanagan, can you please state, oh, I'm so sorry.
That's okay. I'm just peeking in. Stephen Garcia on behalf of the state. Good afternoon, Your Honor.
Good afternoon. And Mr. Flanagan, can you please state your first and last name and your date of birth?
Patrick Flanagan, 7/29/1965.
Mr. Flanagan, you were here today because you were charged with one count of aggravated assault, a Class 3 felony. Mr. Hendrickson, did you want to be heard on probable cause?
No, Your Honor.
So I did find probable cause as to that offense, and I do know that you already have counsel to represent you. And I'm sorry, I was looking over your notice of appearance very quickly. Mr. Hendrickson, is that full representation or just limited notice of appearance?
It's a limited notice of appearance, Your Honor. I believe I will believe it will be full representation. At the time I filed that, I didn't know the charge, and so I couldn't give a full detail of what the representation would include. I just learned the charge in the last 30 minutes, so I need to discuss it with Mr. Flanagan. I believe it will be full representation, but if you want to appoint, and then I can file a substitution after I'm able to further discuss it with him, I will leave that to the discretion of the court.
So just in the abundance of caution, I did make a finding of indigency just based on the financial assessment that I reviewed. And I did appoint counsel. So however way you need to move forward, Mr. Flanagan will have the assistance of counsel in this matter. There is a status conference hearing scheduled for May 1st at 8:30 and a preliminary hearing scheduled on May 5th at 8:30. I did review the state's recommendations for release conditions and bond. Mr. Garcia, do you want to be heard further on that? You're muted, Mr. Garcia.
Sorry about that, Your Honor. Just for the defense's benefit, Your Honor, the state is requesting a $50,000 secured appearance bond based on the nature of the offense. Thank you, Your Honor.
And Mr. Hendrickson, do you want to be heard on release conditions and bond at this time?
Yes, Your Honor, please. The defendant is a 59-year-old man. He has no prior convictions except what I saw in the Form 4, which is judicial interference from 25 years ago. Obviously, no felony arrests or felony convictions, no failures to appear. He's employed as an electronics technician. He's a family man. He's been married 23 years. He has one child who's graduated college, one child in college, one minor child at home. In fact, he informed me how upset he was at the fact that, upset with himself at the fact that his son has a playoff game tonight that he's missing. He just wants to go home. I think a $50,000 bond is prohibitive. I think that pretrial services would be adequate. Obviously, he's hired private counsel, and I believe he's going to continue to have private counsel. He's not at risk of failure to appear, despite the allegations against him that are a serious offense. He's not a danger to the community. And I would ask for OR release and at the most pretrial services. I think a $50,000 bond is, like I said, prohibitive and will be very difficult to post.
So the court did take into consideration the recommendations of the state. I did have an opportunity to review the criminal history that was provided, as well as counsel's arguments for a requested type of relief. In making a determination as to whether or not to impose bond, I do have to look at the safety of the community, as well as what is fair and required, and also looking at the nature of the offense. What was of concern to me in reviewing the Form 4 statement is that there were 2 alleged victims, and the incident is described essentially as road rage, and allegedly a weapon was involved in that. So I do have to take those factors into consideration in determining what would be the appropriate release conditions. So I do believe that a secured appearance bond in the amount of $15,000 is appropriate, with the additional release condition that he cannot return to the scene of the alleged crime, cannot initiate any contact with the alleged victims, and he cannot possess any weapons. Failure to comply with the release conditions or to appear for your court dates would result in the forfeiture of any bond that is posted. A warrant would issue for your arrest, and additional bond could be imposed. Mr. Hendrickson or Mr. Garcia, do you want to be heard any further based on what I have ordered?
No, thank you, Your Honor.
Your Honor, I couldn't decipher if you said 15,015 or 50,050.
15,000.
And that's a secured bond?
Yes.
Thank you, Your Honor. Nothing further.
Okay, Mr. Hendrickson, we will email you a copy of the release condition. If there's nothing further from either counsel, you may be excused. Mr. Flanagan, if you'll please step to the left, officer will give you your paperwork. Mr. Garcia, were you planning on appearing on any other matter this afternoon?
No, Your Honor, unless you need me.
No, thank you. You may be excused. Thank you both. Have a good evening.
Thank you.
Thank you, Your Honor.
Mr. Lechuga, if you will please come into the courtroom, and Miss Salway, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Yeah, good evening, Your Honor. My name is James Alexander Lechuga, and my date of birth is January 1st, 2004.
You are here today on a new case. You were charged with 1 count of possession of a dangerous drug, a Class 6 felony, 1 count of possession of drug paraphernalia, a Class 6 felony, 1 count of criminal trespass, a Class 1 misdemeanor, 1 count of criminal damage, a Class 1 misdemeanor, and 1 count of criminal damage involving drawing on a property, a Class 2 misdemeanor. I did find probable cause as to all of the counts, and I did appoint an attorney to represent you. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $5,000. If you are able to post bond, you cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim, and you cannot have any contact with the alleged co-defendant, and nor can you possess any weapons, and you must contact your probation officer within 72 hours of your release. Failure to comply with your release conditions or to appear for your court dates will result in a forfeiture of any bond that was posted. A warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will please step to your left, officer will give you your paperwork.
Can I ask you one thing real quick? Is the 5,000 set in stone? Like, is there any way I can get a bond reduction for that?
I'm not going to do that. I will let you know, sir, that I did review your history. I know that you were just recently, we just saw you, and like 2 days ago on the 22nd.
I just relapsed, man. Shit goes haywire when that happens.
Okay, so number one, please don't swear.
I apologize.
That's not appropriate behavior and language in court. Number two, what I'm looking at is an escalation in behavior, because it's not just that you relapsed, but also there's an alleged victim involved going into somebody's home without permission and potentially creating property damage within that home. So you had an opportunity to be released on a lower bond, and you turned around and allegedly that committed some more crimes that are very serious. So I don't believe that you're safe in the community right now. I'm concerned that if you were released, that there would be maybe more victims, and I don't think that's good for you either, that you're already pending criminal matters. You don't want to sit here and continue to generate more and more offenses, right? You need to just take care of your stuff and take care of yourself. It's not that I'm unsympathetic or that I don't understand addiction, but right now you're not taking care of that piece, and that does affect your ability to make good decisions that then other people are hurt by those bad decisions. So that takes care of everything that I have to tell you about. I mean, I'm not going to change the bond. It is what it is right now.
So 5,000.
Secured appearance.
So cash.
10% of $5,000.
That's doable. Okay. All right. Thanks. Thank you, Your Honor.
You are welcome. Ms. Salway, if you'll please come into the courtroom, and oh, I'm so sorry. Mr. Duncan, if you'll please have a seat in the chair. Ma'am, can you please state your first and last name and your date of birth?
UCC 1-308, Bonnie Sophia Salway. All right to serve without prejudice.
So you were here today on a new case. You were charged with 1 count of aggravated DUI, driving with a suspended license, or a license that has been suspended because of a previous DUI, a Class 4 felony, and 1 count of assault with intent to injure, a Class 1 misdemeanor. I did find probable cause as to both counts, and I did appoint an attorney to represent you. You will have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $5,000. If you are able to post bond, you'll be released to pretrial services where you will participate in drug and alcohol testing and monitoring. You will also be released on electronic monitoring. You cannot return to the scene of the alleged crime. You cannot have any contact with the alleged victim. You cannot possess any weapons. If there are any orders of protection or orders against harassment that are issued, you must comply. You must comply with those orders. You cannot reside at the same location as the alleged victim. You are permitted 1 civil standby with local law enforcement to assist you in collecting your essential belongings. If you violate the no victim contact order, in this case, you could be charged with aggravated harassment, which is a Class 6 felony. Failure to comply with your release conditions or to appear for your court date would result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. So this takes care of everything that I needed to advise you of this evening. If you don't have any questions for me regarding your release conditions.
Yeah, I don't understand how you're trying to keep me under threat, duress, and corrosion when the car was parked in a parking lot. So how can I get a DUI with a parked vehicle in the
That is a legal question for you to present to your attorney if that's what you'd like to raise as a defense. The standard that I
will get your oath of office. Thank you.
So, officer.
I will get your oath of office.
Okay. Mr. Duncan, will you please come into the courtroom? Sir, can you please state your first and last name and your date of birth?
Sean Duncan, October 20th, 2006.
You are here today on two matters. You have one new case, and then you have a violation of probation. On your new case, you were charged with one count of theft of means of transportation, a Class 3 felony. I did find probable cause as to that offense, and I did appoint an attorney to represent you. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $5,000. As to your violation of probation, I appointed an attorney to represent you in that matter as well. You do have a probation violation possible disposition hearing on May 2nd at 8:30. In that matter, you have a secured appearance bond in the amount of $750. So between your two cases, you have a total secured appearance bond of $5,750. If you are able to post bond, you do need to contact your probation officer within 72 hours of your release. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim, and you cannot possess any weapons. Failure to comply with your release conditions or to appear for your court dates will result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will please step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Mr. Caldwell, if you will please come into the courtroom, and Mr. Victor Gonzalez, if you will please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Yes, ma'am. Christopher Ryan Caldwell, December 16, 1988.
You are here today on two matters. You have one new case, and then you have a violation of probation. I'm going to first talk to you about your new case.
No, ma'am.
You were charged with one count of robbery, a Class 4 felony, and one count of threatening or intimidating with injury or damage to property, a Class 1 misdemeanor. I did find probable cause as to both counts. I did appoint an attorney to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $25,000. As to your violation of probation, I appointed an attorney to represent you in that matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. In that matter, you have a secured appearance bond in the amount of $500. So your total secured appearance bond is $25,500 between the two cases. If you are able to post bond, you do need to contact your probation officer within 72 hours of your release. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim, and you cannot possess any weapons. Failure to comply with your release conditions or to appear for your court dates would result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to advise you of today. If you have no questions for me regarding your release conditions.
No, ma'am.
Okay, thank you. Just step to your left, officer will give you your paperwork. Mr. Gonzalez, will you please come into the courtroom? And Mr. Stockhinger, if you'll please have a seat in the chair. Yes, sir, can you please state your first and last name and your date of birth?
Victor Gonzalez, 04/02/1995.
You are here today on a new case. You are charged with one count of aggravated DUI, driving with a license that's been suspended for a previous DUI, Class 4 felony. I did find probable cause for that offense, and I did appoint counsel to represent you. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $2,500. If you are able to post bond, you will be released to pretrial services where you will participate in alcohol testing and monitoring. Failure to comply with your release conditions or to appear for your court dates would result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you'll please step to your left, the officer will give you your paperwork.
What does that mean that you mentioned May 1st and May 5th?
Those are your upcoming court dates.
Okay. Thank you.
Mr. Stockinger, will you please come into the courtroom? And Ms. Tapia, if you'll please have a seat in the chair. Yes, sir, can you please state your first and last name and your date of birth?
Matthew Steckinger, 7/27/1994.
You are here today on a new case. You were charged with 1 count of escape in the 3rd degree, a Class 6 felony, and 1 count of false report to law enforcement, a Class 1 misdemeanor. I did find probable cause as to both counts, and I did appoint an attorney to represent you. You will have a status conference hearing on May 1st at 8:30, and then you will have a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $2,500. If you're able to post bond, you cannot return to the scene of the alleged crime, and you must appear for your court dates. Failure to do so would result in the forfeiture of any bond that you posted. A warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, you'll please step to your left. The officer will give you your paperwork. Thank you.
Thank you.
Ms. Tapia, will you please come into the courtroom? And Mr. Alex Rivera, if you'll please have a seat in the chair. Yeah, ma'am, can you please state your first and last name and your date of birth?
Nevada Tapia, 9/27/03.
You are here today because we have two warrants. 1 warrant was issued out of our Superior Court for failing to appear for a court date, and then you have a warrant out of Tolleson Municipal Court. I am going to talk to you first about your warrant for failing to appear. I did not appoint an attorney to represent you because an attorney was already appointed to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You have a secured appearance bond in the amount of $2,500 pursuant to the warrant. Then as to your warrant out of Tolleson Municipal Court, I did appoint an attorney to represent you in that matter. You will have an arraignment hearing on May 5th at 8:30. I did order a placeholder bond in the amount of $100 that will ensure that you get transported to your court date since a bond was ordered in your case that would hold you here. So your total bond between the 2 cases is $2,600. Failure to comply with release conditions or to appear for your court date would result in the forfeiture of your bond that you posted. Warrants would issue again, and additional bond could be imposed. That takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will step to your left, the officer will give you your paperwork. Thank you. Mr. Rivera, if you will please come into the courtroom, and Ms. Griffin, if you will please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Alex Rogelio Rivera, December 8, 1990.
You were here today because you have 2 warrants that were issued as a result of a violation of probation. I did appoint an attorney to represent you in both matters. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. Your first warrant has a secured appearance bond in the amount of $1,000. Your second warrant has a secured appearance bond in the amount of $100. So between the 2 cases, you have a secured appearance bond in the amount of $1,100. You need to follow your release conditions. If you're able to post bond, you need to comply with your release conditions as well as appear for your court dates. Failure to do so would result in the forfeiture of any bond that you post. Warrants would issue for your arrest again, and additional bond could be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding release conditions, you step to your left. The officer will give you your paperwork. Ms. Griffin, if you will please come into the courtroom, and Mr. Cruz, if you'll please have a seat in the chair. So, ma'am, can you please state your first and last name and your date of birth?
Yes, Ariana Jamelia Griffin.
You are here today on 2 matters. You have 1 new case, and then you do have a violation of probation. I'm going to talk to you about your new case. You were charged with 1 count of possession of a narcotic drug, a Class 4 felony, and 1 count of criminal trespass, a Class 6 felony.
Criminal trespass. Sorry.
I'm going to give you an opportunity to ask any questions after I complete my advisement to you, okay?
Yes, ma'am.
So I did find probable cause as to those 2 counts, and I did appoint an attorney to represent you. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30, and you have a secured appearance bond in the amount of $500. As to your violation of probation, I did appoint an attorney to represent you in that matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. You have a secured appearance bond in the amount of $250. So between the two cases, you have a total secured appearance bond in the amount of $750. If you are able to post bond, you cannot return to the scene of the alleged crime. You can't initiate any contact with the alleged victims. You cannot possess any weapons, and you'll need to contact probation within 72 hours of your release. Failure to comply with your release conditions or appear for your court dates would result in the forfeiture of any bond you post. A warrant would issue for your arrest. An additional bond could be imposed. I do understand that you may have some statements that you'd like to make. I would just caution you that your questions should only be related to your release conditions. Legal questions should be directed to your attorney that I have appointed for you.
I went through a whole process of being taken off probation already. Literally.
According to our court, you are still on probation, and that is what has been violated. When I'm looking at your court history, what happened, I think that you are mistaking that your probation warrant, the warrant was quashed. You weren't taken off of probation. There was a warrant that was issued and it was quashed in January. So now with this new offense, that automatically triggers a violation of probation. Term 1 of your probation conditions is that you have to abide by the laws and not have police contact. And so you're here today on a new case. That's what triggered the violation of probation. So I think that's pretty much all I can do as far as answering your questions. So if you'll step to your left, the officer will give you your paperwork.
Okay, so I will have to be on bond to get out?
Yes, 10% on $750. I believe that's $75.
$75? Okay, thank you. Thank you.
Mr. Cruz, if you'll please come into the courtroom, and Mr. Victor Rodriguez, if you'll please have a seat in the chair. Hello, sir. Can you state your first and last name and your date of birth?
Yes, it's Michael Cruz, 8787.
You are here today because a warrant was issued for your arrest when you failed to appear for a court date. Yes. An attorney was already appointed to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. The warrant had a secured appearance bond in the amount of $250 for the first one, and the other one, same amount, $250, and you would have the same court dates, May 1st and May 5th at 8:30. If you are able to post bond, you do need to make sure that you comply with your release conditions and that you appear for your court dates. If you fail to do so, any bond that you posted would be forfeited. Another warrant would issue for your arrest, and additional bond can be imposed. It looks like you have a question.
So those charges are from a long time ago.
You never showed up to court.
I know, ma'am. I apologize for that. I just need to get home to my daughter, though. There's nobody there with her.
Sir, it's not that I'm unsympathetic. You're sitting here telling me that these charges have been pending since 2021.
I know, and I've been trying to take care of them. I've just been scared, man. I've been scared.
Well, scared got you in jail.
Yeah.
And scared has a bond on you now.
Okay, so
and you're telling me that because you were scared, you didn't come to court and you didn't take care of it, so...
No, I was scared because my lawyer told me that I was going back to prison. That's what he told me, straight up. I was going back to prison.
Well, that makes it even worse.
That's why I know. That's why I was scared.
Because you're saying that you were scared and you didn't come to court, and if you think that you're going to prison, that you really may not come to court. So the more that you're talking is making it less and less likely that it would be appropriate to release you without bond when you've been on warrant status for a very long time.
I will be here, ma'am.
I'm not reducing the bond.
So what do I owe?
The bond between the two cases is secured appearance, $500.
$500? Thank you, ma'am.
Mr. Lopez, Mr. Benito Lopez, if you'll please come to the courtroom, and Mr. Tosi, if you'll please have a seat in the chair.
Victor Rodriguez.
Oh, I'm so sorry. No, I just did Victor Rodriguez. I'm asking for Benito Lopez. Oh, I'm so sorry. No, I'm not. Wait, where are we at? Okay, whichever one is ready, Victor Rodriguez or Benito Lopez. I will take either one. Just somebody please come in.
Rodriguez?
Thank you. Hello, Mr. Lopez. Can you please state your first
No,
and
it's
last
Victor
name?
Rodriguez.
Oh, wait. Oh, okay. Got it. I am so sorry.
It's fine.
Can you please state your first and last name and your date of birth?
Victor Rodriguez, 12/01/89.
You are here today because a warrant was issued when you failed to appear for a court date. An attorney was already appointed. Wait, no, this cannot be right. Hold on a second. Yep. A warrant was issued when you failed to appear for a court date. An attorney was already appointed to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. The warrant had a secured appearance bond in the amount of $500. If you're able to post bond, you do need to make sure that you appear for your court date. Failure to appear would result in the forfeiture of any bond that you post. Another warrant would issue for your arrest and additional bond could be imposed. So that takes care of everything that I needed to advise you of today. If you have no questions for me regarding release conditions, if you'll please step to your left, officer will give you paperwork.
The probation revocation, that means I have a.
You were supposed to go to court for, I believe, a violation of probation. Petition was filed. You had a court date, and you did not appear for that court date. You were seen here on September 11th, 2024, for your original petition for violation of probation.
I didn't know about it.
No, you were here. You received an order.
No, yeah, but.
And you had a bond of $900 that it looks like you paid. You were released. And then you had a court date on September 18th, and you did not show up to court.
Yeah, I couldn't make it.
So, yeah, but so now a warrant issued, and that's what your bond is.
So if I pay that bond, I could be released?
Yes.
Okay, thank you.
Mr. Lopez, will you please come to the courtroom? And Mr. Tosi, if you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
Benito Lopez, September 25th, 1980.
You are here today because you have a warrant was issued as a result of a violation of probation. I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. You do have a secured appearance bond in the amount of $100. If you are able to post bond, you do need to make sure that you appear for your court date. Failure to comply with your release conditions or appear for your court date would result in the forfeiture of any bond that you post. Another warrant would issue for your arrest, and additional bond could be imposed. So that takes care of everything that I needed to advise you of this evening.
So I'll be in jail until that gets paid off?
Well, you will be in jail. If you can pay your bond, you'll be released. It's 10% of $100. If you can't, then you'll be seen on May 2nd.
All right.
Okay, so we'll step to your left, officer. I'll give you paperwork. Thank you. Mr. Tosi, if you'll please come into the courtroom, and Ms. Foster, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Lionel Celsi, 11/27/83.
You are here today because you have two warrants. Your first warrant is out of El Centro Justice Court.
Where? I'm sorry.
You have a warrant that was issued out of El Centro Justice Court. I did appoint an attorney to represent you in that matter. The warrant was issued because you failed to appear for a court date. You do have an arraignment hearing on April 30th at 8:30. You do have a secured appearance bond in the amount of $250 in that matter. Your second warrant is out of North Mesa Justice Court. I did appoint an attorney to represent you in that matter as well, and it looks like that warrant was also, that warrant was issued as, I don't know if that matter was adjudicated and you had some fees or fines that you were supposed to pay.
Yes, it fines.
But I did just give you some so I appointed an attorney to represent you. You have an arraignment hearing on April 30th at 1 o'clock. I did give you a placeholder bond in the amount of $50 to make sure that you get transported to that hearing. The bonds would just allow that you get transported to your different court dates while you're in custody. This takes care of everything. Well, I'm so sorry. If you're able to post bond, you need to appear for all of your court dates. If you fail to
How much is the bond?
So were you not listening to anything that I said?
I'm sorry, you said it's $50 or something?
$50 for this one, $250 for the other. So your
Okay.
total security appearance bond is $300.
Okay, I got a question. That first warrant, where is that one from?
You literally were not listening to what I was saying.
No, I mean, I was listening, but I don't
It's
remember.
El Centro Justice Court.
El Centro?
That's the name of the Justice Court. And the charges were that you failed to appear on, it was 1 count of DUI, 1 count of DUI with a BAC of .08 or more, and then extreme DUI with the BAC of .15 to .20, and another extreme DUI with a BAC of .20 or more. And the date of those alleged offenses was August 25th of 2024.
Okay, so that one, I showed up to court. I showed up to that very first court that they gave me, and they didn't have a court date set for me. So I actually have a piece of paper from the court saying that I showed up and that I didn't have any charges or nothing was in their computer system saying that I had to be at court at that time and that day.
I'm looking at something completely different because for that court, I'm able to look at your calendar of events and hearings.
Yeah.
You did not appear.
I even called back to the court like a month later to see if I had anything pending, and they still told me no. And like I said, I have a piece of paper from the courtroom or from the the court office or whatever, saying that I showed up, what time I showed up, that they didn't have anything in their system saying that I had to be at court, and I have that in writing, and they stamped it for me.
I don't have it. You don't have the paperwork for me to see, and so all I'm looking at is their history from that court.
Mm-hmm.
It has all their information regarding your court dates, and the court actually, you had a hearing, you did not show up, and then it looks like they, on the court's own motion, they tried to reschedule it, and then they tried to mail you the information regarding it, and then you had a court date on March 27th, and you failed to appear for that, and so
Yeah,
this has been going on for some time.
Yeah, I didn't get anything in the mail. Like I said, I just have that piece of paper with me at home that they stamped for me and everything, and I never got anything after that.
Well, there's nothing I can do about it. I can only go by based what's in the system, and
Yeah.
your warrants have been confirmed, so without having any other information to the contrary, I can't change anything. So what I did, and quite frankly, on this one, your bond was actually $500, and I lowered it to $250.
Okay.
And on your other one, your bond was $500, and I lowered it to $50.
Okay, thank you.
To give you a chance, because I don't know what the circumstances were.
Yeah,
So that's the best that I felt that I could do for you.
thank you.
Ms. Foster, will you please come into the courtroom? Ma'am, can you please state your first and last name and your date of birth?
Samantha Foster, 9/9/1992.
You are here today because you have one new case and one violation of probation. On your new case, you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, 1 count of possession of drug paraphernalia, a Class 6 felony, and 1 count of giving a false report to law enforcement, a Class 1 misdemeanor. I did find probable cause as to all 3 counts, and I did appoint an attorney to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. You have a secured appearance bond in the amount of $500. As to your violation of probation, I did appoint an attorney to represent you in that matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. That warrant had a secured appearance bond in the amount of $500. So between the 2 cases, you have a total secured appearance bond of $1,000. If you are able to post bond, you do need to make sure that you contact your probation officer within 72 hours of your release. You cannot possess any weapons, and you need to attend all of your court dates. Failure to do those things will result and a forfeiture of any bond that was posted. A warrant would issue for your arrest, and additional bond could be imposed. So that takes care of everything that I have to advise you of this evening.
So I didn't qualify for the pretrial or whatever?
You didn't qualify for pretrial because you are already on warrant status for something else, and I think part of that, you're on probation, and it looks like your whereabouts were unknown, and that's part of the reason why your probation was violated.
That's because I had a family member pass away, and I ended up in a car accident and in the hospital.
This warrant was issued on March 17th of 2025.
I've been in the hospital for over, 2 months.
I'm going to advise you to stop making statements because I do have the ability to go and review your probation notes.
Go ahead.
And this is a recorded hearing. Mr. Hallert, will you please come into the courtroom? And Mr. Martinez, if you'll please have a seat in the chair.
Hello.
Hello, if you'll please have a...
Say that again?
No, I was just going to tell you to go to the podium. Can you please state your first and last name and your date of birth?
That's Ethan Daniel King and 12/30/2000.
Thank you. You are here today because you have a warrant out of Hacienda Justice Court. Due to the nature of the offense, you are not entitled to a court-appointed attorney. You will have an arraignment hearing on May 14th at 9 a.m. I am inclined to release you on your own recognizance today, but you do have to promise to appear for your court date. Do you promise to appear for your court date?
Yes.
Failure to appear for your court date will result in another warrant issuing for your arrest and a bond will be imposed. Do you understand?
I'm going to put it in my calendar.
Well, you're going to also get the paperwork, so
okay,
don't lose your release order. So if you'll step to your left, officer will give you your paperwork. Thank you.
I apologize for all my responsibilities. Thank you. Have a beautiful day.
Mr. Martinez, will you please come into the courtroom? And Mr. Monge, I'm so sorry if I'm pronouncing your last name wrong. If you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
John Martinez, December 31st, 1957.
Sir, you were here today on a new case. You were charged with 1 count of burglary in the second degree, a Class 3 felony, and 1 count of trafficking stolen property, a Class 3 felony. I did find probable cause as to both counts, and I did appoint an attorney to represent you. You do have a status conference hearing on May 9th at 8:30, and you have a preliminary hearing on May 13th at 8:30. I'm inclined to release you to pretrial services. You do have to promise to appear for your court date. Do you promise to appear?
Yes, ma'am.
Failure to comply with your release conditions, which include that you cannot return to the scene of the alleged crime, you cannot initiate any contact with the alleged victims. So if you fail to comply with those release conditions or to appear for your court dates, a warrant will issue for your arrest and a bond will be imposed. Do you understand?
Yes, ma'am.
Okay, so if you'll please step to your left, officer will give you your paperwork. Thank you.
Yes. Good morning, or good afternoon.
Can you please state your first and last name and your date of birth?
Jorge Monge, birthday is April 9, 1992.
Thank you. You are here today on a new case. You are charged with 1 count of possession of a dangerous drug, a Class 4 felony, and 1 count of possession of drug paraphernalia, a Class 4 felony. I did find probable cause as to both counts, and I did appoint an attorney to represent you. You will have a status conference hearing on May 9th at 8:30 and a preliminary hearing on May 13th at 8:30. I'm inclined to release you to pretrial services, but you do have to promise to appear for your court dates. Do you promise to appear?
Yes, Your Honor.
You cannot return to the scene of the alleged crime as one of your release conditions. You do have to comply with your release conditions as well as appear
So
for
I have
your
a
court
question. So it happened at the light rail on Alma School?
Stop.
All right.
I'm going to tell you this, just from doing this long enough, that sometimes people talk themselves into a stay here. I've already advised you that I'm going to release you to pretrial services.
All right. Sorry.
So I'm just telling you what your release conditions are. All right?
Yes.
Okay. So comply with your release conditions and appear for your court dates.
Yes, Your Honor.
If you fail to do those things, a warrant will issue for your arrest and a bond will be imposed. Do you understand?
Yes, Your Honor.
Okay, so if you'll step to your left,
Thank you.
officer will give you your paperwork. Ms. Guzman, will you please come into the courtroom? And Mr. Redding, if you'll please have a seat in the chair. Hello, can you please state your first and last name and your date of birth?
Kirsten Guzman, 32104.
You are here today on a new case. You were charged with 1 count of possession of dangerous drugs, a Class 6 felony, 1 count of possession of drug paraphernalia, a Class 6 felony, and 1 count of criminal trespass, a Class 1 misdemeanor. I did find probable cause as to all 3 counts, and I did appoint an attorney to represent you. I think I have to change, Kayla, I think this. Give me 1 moment to go back and look at the form for it, because I believe that there is a co-defendant here. And they have the same agency, and they shouldn't. Okay, no, I did make the change. Okay. So, we are good to go forward. I did appoint an attorney to represent you in this matter. You do have a status conference hearing on May 9th at 8:30 and a preliminary hearing on May 13th at 8:30. I'm inclined to release you to pretrial services today, but there are some release conditions that you will have to comply with, and you have to promise to appear for your court dates. Do you promise to appear?
I do.
You cannot return to the scene of the alleged crime. You cannot have any contact with the alleged victim, and you cannot have any contact with your co-defendant. Failure to comply with your release conditions or to appear for your court dates will result in a warrant issuing for your arrest, and a bond would be imposed. Do you understand?
Yes, Your Honor.
Okay, so if you have, this completes my advisement to you. If you have no questions for me regarding your release, if you'll step to your left, the officer will give you your paperwork. Mr. Redding, will you please come into the courtroom? I have to fix this one too, because it didn't show that it's, it didn't save my no PC. You do? On my screen, I don't. So I just want to make sure. Okay. Okay, sir, can you please state your first and last name and your date of birth?
Yeah, John Sebastian Redding, July 17th, 1982.
Thank you. You are here today for, you were charged, on a new case, you were charged with 1 count of aggravated DUI involving an interlock, a Class 4 felony. I did not find probable cause for this offense. I did appoint an attorney to represent you. You will have a status conference hearing on May 9th at 8:30 and a preliminary hearing on May 13th at 8:30. Although I did not find probable cause today, does not mean that this case goes away. Just as of today, I was not provided with enough information to make that finding. Did you know?
They were kind of talking out there. I couldn't hear you what you said.
I did not make a probable cause finding today for the charge, but that does not mean that you still do not have to show up to court.
Okay.
On the dates that I told you. I was not given enough information to make a probable cause finding today. That information could be supplemented before you get to your next court date, so make sure that you show up to your court date, okay?
Okay.
All right, that takes care of everything that I have to tell you today. The officer is going to give you your paperwork. You are being released.
I'm being released?
You are being released.
Okay, good.
This concludes the 5 p.m. initial appearance calendar. We stand in recess until 8 p.m. This is the court. Are you able to hear the court? This is the court. Are you able to hear the court?
This is Kyle Reedy, and I can hear you now, yes.
So we couldn't hear any of the court, any of the hearing. Okay. Ms. Heck, will you please come into the courtroom? And Mr. Torre, if you'll please have a seat in the chair. Okay, I guess, go ahead, come on in, Ms. Heck, and then I'm just gonna, I have to make a record. Apparently the other hearings, the FTR did not pick them up, so I do have to make a record. So my apologies to everybody, but I'm just gonna run through the calendar very quickly. Mr. Perez, date of birth, February 20th, 1992. He appeared in court in person on a new case. He was charged with 1 count of possession of a dangerous drug, a class 4 felony, and 1 count of possession of drug paraphernalia, a class 6 felony. The court did find probable cause as to those offenses and did appoint an attorney to represent him. He had a status conference hearing on May 1st at 8:30, an evidentiary hearing on May 2nd at 1:30, and a preliminary hearing on May 5th at 8:30. Mr. Perez was advised that because he was on felony release at the time that these alleged offenses occurred, he was not eligible for bond, and that is why the court set an evidentiary hearing for him. Ms. Angelique Porter, date of birth, October 14th, was here on 2 matters, both of them involving warrants that were issued because she failed to appear for her court date. She had a status conference hearing. She had a status conference hearing on May 1st at 8:30 and an evidentiary hearing on May 2nd at 1:30. She was not eligible for bond because she was pending sentencing at the time that she failed to appear for her court date. On her second matter, she had a status conference hearing for May 1st at 8:30. An attorney was not appointed to her in either matter because one was already appointed to her. She has a cash-only bond in the amount of $1,000. She was cautioned against posting that, given the fact that she was not bondable in the prior matter. Lucas Purdy, date of birth April 26, 1986, was present in person. He was here on a new case. He was charged with 1 count of theft of means of transportation, 1 count of possession of a dangerous drug, a class 4 felony, 1 count of possession of a weapon by a prohibited person, a class 4 felony, 1 count of a possession of a weapon used during a drug offense, a class 4 felony, 1 count of unlawful flight from law enforcement, a class 5 felony, and possession of drug paraphernalia, a class 6 felony. The court did find probable cause as to all of the offenses except for the possession of a dangerous drug. He was appointed counsel. He has a status conference hearing on May 1st at 8:30, a preliminary hearing on May 5th at 8:30. He had a secured appearance bond in the amount of $25,000. Mr. Purdy was advised that if he failed to comply with his release conditions or appear for his court dates, any bond that he posted would be forfeited, a warrant would issue for his arrest, and additional bond would be imposed. Mr. John Perez, date of birth August 1st, 1995, was here in person. He's here on a new case. He was charged with 1 count of assault with an intent to injure, a class 1 misdemeanor, as well as 1 count of disorderly conduct involving fighting. The court did find probable cause and did appoint an attorney for him. The court did attempt to make a record of regarding the reasons for the release conditions that the court set. The court noted that Mr. Perez has been seen by this court multiple times for domestic violence related charges. The court was concerned about the escalation and the seriousness of the offenses and the concerns for the safety of the victim. He was advised of a number of release conditions, and that if he has a cash bond of $5,000. He was advised that if he failed to comply with the number of release conditions that the court did review with him, that would result in a forfeiture of his bond and a warrant issuing for his arrest and additional bond being issued, as well as if he failed to appear, a warrant would issue for his arrest. Mr. Paul Brown, date of birth November 25th, 1965, was here in person on a new case. He was charged with 1 count of dangerous drugs for sale, a class 2 felony. The court did find probable cause and did appoint an attorney to represent him. He does have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. He does have a secured appearance bond in the amount of $15,000. Mr. Brown was advised that if he fails to comply with his release conditions or appear for his court dates, that any bond that he posts would be forfeited, warrants would issue for his arrest, and additional bond would be imposed. Mr. Flores, date of birth August 29th, 2000, was here in person for a new case. He was charged with 1 count of aggravated DUI, driving the wrong way, class 4 felony, 1 count of DUI involving liquor, drugs, vapors, or a combination thereof, a class 1 misdemeanor, and 1 count of reckless driving, a class 2 misdemeanor. The court found probable cause as to all 3 counts and did appoint counsel to represent him. He has a status conference hearing on May 1st at 8:30, a preliminary hearing on May 5th at 8:30. He has a secured appearance bond in the amount of $5,000. If he's able to post bond, he will be released to pretrial services while he will participate in alcohol testing and monitoring. He was advised that if he failed to comply with his release conditions or appear for his court dates, that any bond that he posted would be forfeited, a warrant would issue for his arrest, and additional bonds could be imposed. Mr. Alvin Bedelia, date of birth August 23rd, 1969, was here in person. He was here on a new case. He was charged with 1 count of aggravated DUI, driving with a suspended license, 4 DUI, class 4 felony, 1 count of possession of a dangerous drug, a class 4 felony, 1 count of DUI involving liquor, drugs, vapors, or a combination, class 1 misdemeanor, and 1 count of driving with a suspended or revoked driver's license, a class 1 misdemeanor. I did find probable cause as to all counts. I did appoint counsel to represent him. He has a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. He has a secured appearance bond in the amount of $5,000. If he is able to post bond, he will be released to pretrial services where he is to participate with drug testing and monitoring. Mr. Abedelia was advised that if he failed to comply with his release conditions or appear for his court dates, that any bond posted would be forfeited, a warrant would issue for his arrest, and additional bond would be imposed. That brings us up to Ms. Heck. Sir, do you want to stand next to your client?
Yes.
Sir, would you like to state your appearance at this time?
Yes, good evening, Your Honor. Benjamin Richards covering for Leslie Pugh on behalf of Ms. Heck, who is present in custody to my left.
Ms. Heck, can you please state your first and last name and your date of birth?
Tracy Heck, 3/16/70.
You are here today because you have two matters. You have a warrant out of Sierra Vista's Justice Court, and then you have a violation of probation. You do have counsel here present for you. You do have a violation of, you do have a probation revocation, possible disposition hearing on May 2nd at 8:30. The violation of probation warrant had a secured appearance bond in the amount of $1,500. Sir, did you want to be heard on release conditions?
Yes, Your Honor, just briefly. As the court will note from the Form 4, Ms. Heck retained our firm. She flew here at her own expense to address this issue. She self-surrendered with cash in hand, ready to go to post bond. What we're asking the court to do today is just to affirm the bond imposed by Commissioner Phillips previously, with the special ask of allowing Ms. Heck to reside out of New York where she lives. Ms. Heck has employment there. She works part-time at Domino's. She also receives SSDI. Those are her sources of income. As I noted, Ms. Heck has self-surrendered to this court. She wants to resolve this matter. Regarding the other matter out of Cochise County, Your Honor, the court records show that the direct complaint and summons were never served. Ms. Heck did not have notice of them. Ms. Pugh, when we learned about that, when Ms. Heck previously self-surrendered, called Cochise County, filed a limited notice of appearance as well as an emergency motion to quash the warrant. Unfortunately, a judge doesn't sit on the bench in Cochise County on Friday, so that should be addressed Monday. Again, we're just asking that the court affirm the $1,500 bond previously imposed by Commissioner Phillips and allow Ms. Heck to reside out of state in New York. She lives outside of Albany in an exurb called Amsterdam.
So I only talked about the violation of probation. I hadn't discussed the warrant out of Sierra Vista Justice Court. So with that, she has an arraignment hearing on April 30th at 8:30, and that warrant had a secured appearance bond in the amount of $1,500 as well. I do not change another. That's a court that's not in our jurisdiction, and I don't have access to any of that information. So that warrant is what it is. I can't really do.
Just to be clear, Your Honor, I wasn't asking the court to step outside of its jurisdiction in a Cochise County. I was just advising the court that we just learned about this today when she self-surrendered.
And then as far as issuing orders regarding whether or not a person can reside out of state while their matters are resolving, this court does not do that. That should be something that is brought, that's an ask that should be brought before the judge that this is assigned to, as well as the assigned probation officer. And I don't know if anybody reached out to the assigned probation officer to get that permission. I know that this warrant was issued a few months ago. This warrant,
I believe it was issued in 2023, Your Honor.
It was issued on January 31st of 2023. So based on just the age of the warrant, and it appears that perhaps there was no communication with probation up until now, that I would not be inclined to allow your client to travel back to New York without first appearing in front of the assigned judge on this matter.
We'll file a motion with the probation violation judge, Your Honor. Thank you.
Okay. So I believe that I've gone over both warrants now. So the total secured appearance bond between the two cases is $3,000. If you are able to post bond, you do need to make sure that you follow all the release conditions and that you do appear for your court date. If you fail to do so, any bond that you post would be forfeited. Warrants would issue for your arrest again, and additional bond could be imposed.
So it's more money?
The $1,500 bond is for this court. There's another bond out of
She said $3,000.
She's doing the math for you.
Is that for both counties, 3,000?
So I'm going to break it down again.
Yeah, I can't hear you.
So for your violation of probation warrant, that's here in this court, for Maricopa County Superior Court, you have a secured appearance bond in the amount of $1,500.
Okay.
For the Sierra Vistas Justice Court, there's that warrant had a secured appearance bond in the amount of $1,500.
Okay.
So with the two cases combined, your total secured appearance bond is $3,000.
Okay. I didn't hear that. Yeah, I didn't hear it. Okay, thank you.
No worries.
Yeah.
So I believe that takes care of everything that I can do here this evening. If you have no other questions, we're going to make sure that, sir, you get a copy of the paperwork, and if you step to the left, the officer will give you your copy of your paperwork.
Okay.
Thank you, Judge.
Sure. We didn't do Mr. Torre yet. Okay. Mr. Torre, can you please come into the courtroom? Hello, sir.
Good evening, Your Honor.
Can you please tell me your first and last name and your date of birth?
Yusuf Levon Teray, May 30th, 1999.
You are here today because a direct complaint was filed where you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, and 1 count of possession of drug paraphernalia, a Class 6 felony. The date of these alleged offenses is October 8th of 2024. I did appoint an attorney to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. I am aware that you were already in custody.
Yes, ma'am.
So I'm just affirming the direct complaint bond in the amount of $1,000. That's just to ensure that you make it to all your court dates while you are in the sheriff's custody. But the admonition that if you fail to comply with your release conditions or appear for your court dates, if you are able to post bond, that would result in a forfeiture of any bond that you post, and a warrant would be issued for your arrest. I would advise, I believe in your other matter, are you being held not bondable in that one?
Huh?
In your other matter, are you being held not bondable?
Well, when I'm already going
The other case that you are here for?
Yeah, on the 28th,
Yeah, okay. So I would caution you against attempting to pay bond right now because it may not result in your release because of the other case.
Yes, ma'am.
Okay, so I think that takes care of everything that I needed to tell you about. So if you will step to your left, the officer will give you your paperwork. Miss Palacio, if you'll please come into the courtroom, and Mr. Collins, if you'll please have a seat in the chair. Hello, can you please state your first and last name and your date of birth?
Kathleen Palacio, July 31st, 1991.
You are here today because a warrant was issued when you failed to appear for a court date. An attorney was already appointed to represent you in this matter. You do have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. Your warrant had a secured appearance bond in the amount of $1,000. If you are able to post bond, you do need to make sure that you appear for your court date and follow your release conditions. Failure to do so would result in the forfeiture of any bond that you post. Another warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will please step to your left, the officer will give you your paperwork. Thank you.
Okay, so I can post bond?
Pardon me?
So I post bond?
You have a secured appearance bond in the amount of $1,000. If you're able to post it, you would be released.
Okay, thank you.
Mr. Collins, will you please come into the courtroom? And Mr. Jones, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Javelle Collins, February 21st, 1986.
You are here today because you have a warrant for violation of probation. I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. Your warrant had a secured appearance bond in the amount of $250. If you're able to post bond, you do need to make sure that you comply with your release conditions as well as appear for your court date. If you fail to do so, that would result in the forfeiture of any bond that you post. Another warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to advise you of this evening. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Mr. Jones, if you'll please come into the courtroom, and Mr. Fulton, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Silas Jones, 9984.
You are here today because you have 2 warrants as a result of a violation of probation, and then you have a warrant out of University Lakes Justice Court. As to your violation of probation warrants, I did appoint an attorney to represent you in those matters. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. Each of your warrants has a secured appearance bond. One has a secured appearance bond in the amount of $250. The other one is in the amount of $100. Then as to your warrant out of University Lakes Justice Court, I did appoint an attorney to represent you in that matter. You do have a arraignment hearing on April 30th at 8:30. You do have a secured appearance bond in the amount of $100. So between your 3 cases, you have a total secured appearance bond in the amount of $450. You must comply with your release conditions as well as appear for your court date. Failure to do so would result in the forfeiture of any bond that you post. Warrants would issue again, and additional bonds could be imposed. So that takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding release conditions, if you will please step to the left, the officer will give you your paperwork. Thank you.
All right, thank you.
Mr. Fulton, will you please come into the courtroom, and Mr. Yana, if you'll please come and have a seat in the chair. Mr. Fulton?
Fulton.
Hello, can you please state your first and last name and your date of birth?
Justin Joseph Shane Fulton, 01/27/2000.
Thank you. You are here today because warrants issued for your arrest and you failed to appear for your court dates. An attorney was already appointed to represent you in these matters. You do have a non-witness violation hearing on May 2nd at 8:30 in both matters. You have a secured appearance bond in the amount of $900 per warrant, so your total secured appearance bond is $1,800. If you are able to post bond, it is important that you comply with your release conditions as well as appear for your court date. Failure to do so would result in the forfeiture of any bond that you post. A warrant will issue for your arrest again, and additional bond could be imposed. That takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you'll please step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Mr. Yanes, if you'll please come into the courtroom, and Mr. Gleistein, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Joseph Duran Yanes Jr., 2/24/1983.
Did you say February 4th, 1983? Yeah. Okay. You are here today for a warrant was issued due to a violation of probation. I did appoint an attorney to represent you. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. You do have a secured appearance bond in the amount of $750. If you are able to post bond, it is important that you comply with release conditions as well as appear for your court date. Failure to do so would result in the forfeiture of any bond you posted. A warrant would issue again, and additional bond could be imposed. That takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you'll please step to your left, the officer will give you your paperwork. Thank you. Mr. Gleistein, if you'll please come to the courtroom. And Ms. Lambert, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Robert Gleistein. It's April 5th, 1987.
Sir, you are here today because a warrant was issued as a result of a violation of probation. I did appoint an attorney to represent you. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. The warrant had a secured appearance bond in the amount of $250. If you are able to post bond, you do need to make sure that you comply with release conditions as well as appear for your court date. Failure to do so would result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. So that takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding release conditions, if you will step to your left, the officer will give you your paperwork.
Thank you, ma'am.
Thank you. Ms. Lambert, will you please come into the courtroom? And Mr. Quintana Sena, if you'll please have a seat in the chair. Hello, ma'am. Can you please state your first and last name and your date of birth?
Jennifer Aaron Lambert, 1284.
Ma'am, you are here today because you have a warrant was issued due to a violation of probation. I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. Your warrant had a secured appearance bond in the amount of $750. If you are able to post bond, you do have to comply with your release conditions as well as appear for your court date. Failure to do so would result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond could be imposed. So that takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will move to your left, the officer will give you your paperwork. Thank you.
Thank you.
Mr. Quintana Sena, if you'll please come into the courtroom. Mr. Reedy, are you appearing on this? Is this the matter that you are appearing on?
Yes, Your Honor.
Okay. Would you like to state your appearance at this time?
Yes, Kyle Reedy on behalf of Mr. Quintana Sena.
Mr. Sena, can you please state your first and last name and your date of birth?
Robert Quintana Sena, 53070.
Sir, you are here today because a direct complaint was filed where you were charged with the following: 3 counts of aggravated driving or actual physical control while under the influence of intoxicating liquor or drugs, a class 4 felony, and 1 count of misconduct involving weapons, a class 4 felony. The date of these alleged offenses is October 26th of 2019. Mr. Reedy, is this a full notice of appearance or is it just for today?
It is a full notice of appearance, Judge, and I've reviewed the Form 4. I know there's already a $750 bond in place if the court is inclined to.
I was not going to do that. I was just trying to figure out if whether or not I needed to provisionally make a finding of indigency in case. That was the reason for my question. Yeah. So you do have a status conference hearing on May 9th at 8:30, and you do have a preliminary hearing on May 13th at 8:30. I did have an opportunity to, well, there was not a Form 4 that was attached, I believe, with this particular direct complaint. I did review the criminal history of Mr. Quintana Sena in considering what the release conditions should be. I note that there hasn't been anything significant that has happened in the last 6 years, so I do believe that it was appropriate to release him to pretrial services. Did you want to be heard on what my inclinations were, Mr. Reedy?
I assumed you were just going to affirm the $750 bond in place, Your Honor. If you're inclined to release him to pretrial services, then I'll leave it to the court's discretion. Thank you.
The additional release conditions are that Mr. Quintana Sena, what is your last name? What do you prefer to be?
Quintana Sena.
Okay, so I am saying it correctly.
Yeah.
That you just cannot possess any weapons, and that you do have to comply with the release conditions of pretrial services. And if you fail to do those things, or if you fail to appear for your court dates, and do you promise to appear for your court dates?
Robbie, sir.
Okay. Failure to appear or to comply with your release conditions would result in a warrant issuing for your arrest and a bond actually being imposed. If there is nothing further from you, Mr. Reedy, we will make sure that you get a copy of this order.
Nothing else. Thank you, Judge.
Okay, so, and if you have no questions for me, sir, regarding your release.
So, when do I gotta go report to pretrial, or?
The paperwork is gonna give you all the information that tells you what you need to do for pretrial services.
All right.
But you will be released. You are not being held with bond.
Oh, is that right? That's easy, huh? Right on, brother. Thank you.
Thank you, Judge.
Mr. Reedy, sure, you may
What?
be excused at this time.
Thank you.
Mr. Hayslip, if you'll please come into the courtroom, and Mr. Nesanov, if you'll please have a seat in the chair.
Hello,
Hello, sir. Can you please state your first and last name and your date of birth?
Scott Hayslip, August 6, 1994.
You are here today because the grand jury charged you with the following. 1 count of possession of narcotic drugs, a class 4 felony, and 1 count of possession of drug paraphernalia, a class 6 felony. The date of these alleged offenses is September 22nd of 2023. I did appoint an attorney to represent you in this matter. You do have an arraignment hearing on May 2nd at 8:30. I'm inclined to release you to pretrial services without bond, but you do have to promise to appear for your court date. Do you promise to appear?
Yes, I do.
You do have some release conditions that you'll have to comply with pretrial services. Failure to comply with your release conditions or to appear for your court date would result in a warrant issuing for your arrest and a bond being imposed. Do you understand?
Yes, ma'am.
If you have no questions for me regarding your release conditions, if you will please step to your left, the officer will give you your paperwork. Thank you.
Okay, thank you.
Hello. Can you please state your first and last name and your date of birth?
David Nisanov, March 15th, 1995.
You were here today on a new case. You were charged with 1 count of assault with intent to injure or recklessness and resulting in injury, a class 1 misdemeanor. I did find probable cause as to this charge, and I did appoint an attorney to represent you. You do have an arraignment hearing on May 13th at 8 a.m. I am inclined to release you on your own recognizance today. You do have to promise to appear for your court date.
Of course.
You do have the following release conditions. You cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim. You cannot possess any weapons. If there are any orders of protection or orders against harassment that have been issued, you must comply with those orders. You cannot reside at the same location as the victim. You are permitted 1 civil standby with local law enforcement to assist you in collecting your essential belongings. You are advised that if you violate the no victim contact order in this case, you could be charged with aggravated harassment, which is a class 6 felony. Failure to comply with your release conditions or to appear for your court date would result in a warrant issuing for your arrest and a bond being imposed. Do you understand?
I understand.
Okay, so that takes care of everything that I needed to advise you of. If you have no questions for me regarding your release conditions, if you'll step to your left, the officer will give you your paperwork.
Thank you, Your Honor.
Ms. Phelps, will you please come into the courtroom? And Ms. Hartzer, if you'll please have a seat in the chair. Hi. Sorry. You're fine. Can you please state your first and last name and your date of birth?
I'm sorry. Victoria Phelps, 12/16/2003.
You are here today for a new case. You were charged with 1 count of possession of a forged instrument, a class 4 felony. I did find probable cause as to that charge. I did appoint an attorney to represent you. You have a status conference hearing on May 9th at 8:30 and the preliminary hearing on May 13th at 8:30. I'm inclined to release you on your own recognizance today, but you do have to promise to appear for your court date. Do you promise to appear?
Yes, of course.
Failure to appear for your court date or comply with your release conditions, which one of them is that you cannot return to the scene of the alleged crime, will result in a warrant issuing for your arrest and a bond would be imposed. So this takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will step to your left, the officer will give you your paperwork.
I just want to make sure I don't have to pay bond today.
I'm releasing you on your own recognizance.
Thank you so much. Seriously, God bless you. Thank you.
Ms. Hartzer, will you please come into the courtroom? And Mr. Lofton, if you will please have a seat in the chair.
Hi.
Hello, can you please state your first and last name?
Sorry, my voice is a little shouty right now. It's Shauna Hartzer, 8/24/81.
You are here today on a new case. You are charged with 1 count of possession of a dangerous drug, a class 4 felony, 1 count of possession of drug paraphernalia, a class 6 felony, and 1 count of possession of a prescription drug without the prescription, a class 2 misdemeanor.
I don't even know what that is. Okay. I honestly don't even know what that one is.
Give me one moment. So the issue with that is that you were in possession of a drug believed to be Xanax, so you didn't have a prescription for it. That is what the allegation is, based on the Form 4. So I did, and then possession of drug paraphernalia, a Class 6 felony. I did find probable cause as to all 3 counts. I did appoint an attorney to represent you. You have a status conference hearing on May 9th at 8:30 and a preliminary hearing on May 13th at 8:30. I'm inclined to release you to pretrial services without bond. You do have to promise to appear for your court dates. Do you promise to appear?
Yes, ma'am, I do. Pretrial conferences.
Your release conditions are that you cannot return to the scene of the alleged crime, you cannot have any contact with any of the co-defendants, and you cannot possess any drugs without a prescription. Failure to comply with your release conditions or to appear for your court date will result in a warrant issuing for your arrest, and a bond would be imposed. That takes care of everything that I needed to advise you of this evening. If you have no questions for me regarding your release conditions, if you will step to your left, the officer will give you your paperwork.
I'm sorry, so I'm released to pretrial?
Mm-hmm.
Okay, thank you. Thank you.
Mr. Lofton, will you please come into the courtroom? Hello, sir. Can you please state your first and last name and your date of birth?
MCT Lofton Jr., 9/18/87.
Thank you. You are here today because you were charged with 1 count of possession of a dangerous drug, a Class 4 felony, and 1 count of possession of drug paraphernalia, a Class 6 felony. I did find probable causes to both counts, and I did appoint an attorney to represent you. You will have a status conference hearing on May 9th at 8:30 and a preliminary hearing on May 13th at 8:30. I am inclined to release you to pretrial services without bond, but you do have to promise to appear for your court date. Do you promise to appear?
Yes, ma'am.
You have the following release conditions. You cannot return to the scene of the alleged crime. You cannot initiate any contact with any of the alleged co-defendants. Failure to comply with your release conditions or to appear for your court date will result in a warrant issuing for your arrest, and a bond would be imposed. Do you understand?
Yes, ma'am.
Okay, so this takes care of everything that I needed to advise you of. If you have no questions for me regarding your release conditions, if you'll step to the left, the officer will give you your paperwork.
Yes, ma'am.
Hi, this is Maria, Spanish interpreter, ID 379735.
Thank you, Madam Interpreter. I'm about to call a matter that requires your assistance. Mr. Marino, will you please come to the podium?
Señor Moreno, ¿puede venir al podio?
Sir, can you please state your first and last name and your date of birth?
Señor, ¿puede por favor decir su nombre, su apellido y su fecha de nacimiento?
Macario Pérez Moreno, marzo 10 de 1998.
Macario Pérez Moreno, March 10 of 98.
Sir, you are here today on a new case.
Señor, ¿usted está aquí el día de hoy en un nuevo caso?
You were charged with 1 count of possession of a dangerous drug, a Class 4 felony.
Usted está siendo acusado con posesión de una droga peligrosa, la cual es un crimen serio.
1 count of possession of drug paraphernalia, a Class 6 felony.
Una acusación de posesión de drogas, que sería un delito mayor clásico.
And 1 count of liquor possession of an open container in a vehicle, a Class 2 misdemeanor.
Y una acusación de alcohol con una bebida abierta, la cual sería un delito menor.
I did find probable cause as to the possession of drug paraphernalia and possession of liquor or open container in a vehicle.
Sí he encontrado una causa probable de la posesión de droga y parafernalía y del contenedor de alcohol abierto.
I did not find probable cause as to the possession of a dangerous drug.
No encontré causa probable de posesión de la droga peligrosa.
I did appoint an attorney to represent you.
He indicado un abogado para que lo represente.
You do have a status conference hearing on May 9th at 8:30.
Tiene usted una junta en audiencia el día 9 de mayo a las 8:30.
You have a preliminary hearing on May 13th at 8:30.
Tiene una audiencia preliminar el día 13 de mayo a las 8:30.
I am going to release you to pretrial services.
Voy a estar indicando unos servicios de prejuicio.
You do have to promise to appear for your court dates.
Tiene que hacer una promesa de aparecer para su cita de corte.
Do you promise to appear for your court dates?
¿Promete usted aparecer para su fecha de corte?
Sí.
One of your release conditions is that you cannot return to the scene of the alleged crimes.
Una de las condiciones que se ha revisado es que no puede usted regresar a la escena del crimen.
Failure to comply with your release conditions.
Al fallar cumplir, ¿estaría usted cancelando las condiciones?
Or failure to appear for your court dates.
O si usted falla el estar presente para su fecha de corte,
will result in a warrant issuing for your arrest.
estaría resultando en que se estaría entregando una orden para su arresto.
And a bond would be imposed.
Y no estaría presente una fianza.
This completes my advisement to you.
Esto estaría cumpliendo mi aviso hacia usted.
If you have no questions for me regarding your release conditions,
Si usted no tiene alguna pregunta para mí en cuanto a las condiciones revisadas,
please step to your left and the officer will give you your paperwork.
por favor, pase a la izquierda, el oficial le va a dar su papeleo.
Gracias.
Thank you.
Ms. Keller, will you please come into the courtroom? And Madam Interpreter, thank you so much. I believe we have no more interpreter matters. Thank you for helping us out this evening.
Thank you for using our service. Have a wonderful night.
Thank you. Ma'am, can you please state your first and last name and your date of birth?
Jalissa Calvert, 7/3/1990.
You are here today because you have a violation of probation.
Yes, Your Honor.
I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. You do have a secured appearance bond in the amount of $500. I do understand that you are currently being held not bondable in another matter, so I would caution you against attempting to pay this bond because you still would not be released. This takes care of everything that I needed to advise you of today. If you have no questions for me regarding your release conditions, if you'll step to your left, officer will give you your paperwork.
No, so I know that you answered the whole not bondable on the original. I didn't really know my rights, or I do know my rights, but I didn't know if I could ask because this situation, I guess you can't talk to me about that one. I'm so sorry. You're right.
So I know that you've been appointed an attorney. In both of your matters, you have an attorney representing you. So any legal questions that you have, address them to your attorney.
Okay.
Okay? So if you'll step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Okay, thank you. Mr. Dawson, will you please come into the courtroom? Sir, will you please state your first and last name and your date of birth?
Frankie Dawson, 1969, or 12/20/1969.
You are here today because a warrant was issued as a result of a violation of probation. I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on May 2nd at 8:30. You do have a secured appearance bond in the amount of $3,500. If you are able to post bond, you do need to comply with release conditions as well as appear for your court date. If you fail to do so, any bond that you post would be forfeited, a warrant will issue for your arrest, and additional bond will be imposed. This takes care of everything that I needed to advise you of today. Excuse me, if you have no questions for me regarding your release conditions, if you will step to your left, the officer will give you your paperwork. Thank you. Mr. Geiger, if you'll please come into the courtroom.
How you doing?
Hello, can you please state your first and last name and your date of birth?
Joseph Overguy, 299-80-9131.
Say that again.
Joseph Robert Geiger, 299-80-9131.
You're not giving your birth date.
Oh, Joseph Robert Geiger, 299-80-9131.
I'm asking.
Oh, 221-83.
Thank you. You were here today for a new case. You were charged with one count of failing to register as a sex offender, a class 4 felony, one count of failing to provide an address, a class 4 felony, one count of indecent exposure, a class 6 felony, and one count of failing a sex offender, failing to register, confirm ID, your identification, a class 6 felony. I did find probable cause as to all of those counts, and I did appoint an attorney to represent you. You do have a status conference hearing on May 1st at 8:30, and you have a preliminary hearing on May 5th at 8:30. You do have a secured appearance bond in the amount of $50,000. If you're able to post bond, you'll be released to pretrial services with electronic monitoring. You also will not be permitted to return to the scene of the alleged crime or initiate any contact with the alleged victims, and you cannot have any contact with any minors, nor can you possess any weapons. Failure to comply with your release conditions or to appear for your court dates will result in the forfeiture of any bond that you post. A warrant would issue for your arrest, and additional bond would be imposed. This concludes everything that I needed to advise you of today. If you'll step to your left, the officer will give you your paperwork.
Yes, I understand my rights. Thank you.
Bernice Martinez is date of birth, April 23rd, 1985, is here on a new case. She's not in court in person due to non-compliant behavior. She was charged with one count of burglary in the 3rd degree, a class 4 felony. I did find probable cause as to that charge. I did appoint an attorney to represent her. She will have a status conference hearing on May 1st at 8:30 and a preliminary hearing on May 5th at 8:30. She will have a secured appearance bond in the amount of $1,000. She cannot return to the scene of the alleged crime, initiate any contact with the alleged victims. She will be advised if she fails to comply with her release conditions or to appear for her court dates. Any bond that she posted will be forfeited. A warrant will issue for her arrest, and additional bond would likely be ordered. I will meet with Ms. Martinez, and if any changes are needed, I will do so either on the record or in writing.